Just give it to him.
July has been an amazing month, and to end the month, we're doing a subscription campaign. And if you want to win a free Starbucks tumbler, just click the subscribe button. That's it. It's easy. Then leave in the comments, "I sub," so we can get you in the drawing. The winner will be announced July 31st. Good luck, everyone, and thank you for subscribing. Oh my God, y'all, we did it. I can't believe it. We actually did it. Exciting news. Memberships have launched. Memberships are a great way to financially support this channel. Starting at the juror level of membership, we will be hosting members-only lives. Also, at the judge level, we will be having VIP events. We hope you will enjoy sporting the membership badges and soon to come exclusive emojis. Thank you for watching and supporting the stream and my dream to provide accessibility to the deaf and hard of hearing. Oh, we're back. And I'm excited. I had a dear friend hop in. I hadn't seen her in a hot minute. Those of you who don't know, who may not know, I'm a professional makeup artist. And I am a part of a company that sells some of the most amazing cosmetics. I've been using their products since, oh gosh, I'm going to date myself now. 1990. Yeah, I was 18, 19 years old when I started being a makeup artist and learning. And the lady that I worked under and taught me used a brand called Alcone, and it's only to professionals. You cannot buy it over the counter. In fact, she traveled to New York literally twice a year to buy all the cosmetics that she needed for her clients. So, anyway, that company is now available publicly. And so, but anyway, that's a cosmetic line I use when I do my makeup. I do weddings, I do all kinds of photo shoots, TV commercial, whatever. So, anyway, I'm excited we got something new. Oh, you're making lunch, yeah. Well, I'm going to get my lunch is getting delivered today, so I'm going to be eating while we're watching. Good afternoon. Oh, you're back. Oh, yay. They are such a delight. She is a love. She's a love. Absolutely love her. She got to see what I do. It's one thing seeing from your perspective. You don't see all the pedaling and the buttons and the switching and everything I'm doing behind scene. Coffee's good, but I'm ready for something cold. I am so ready for a cold drink. So that's on its way. Um, she went, I could not make it to the conference for this company. And she went. And so she brought me the newest launch product for me to see. She also just visited with me. But they're going to be having their conference in Houston next year, and I'm excited. Whole new appreciation when you're able to see your friends work. Yeah, that is so true. You never know what people do. I mean, if you're good at it, it looks easy. If you're good at it, it looks easy. I'm going to zoom back just a hair. My camera is getting wonky again. I've got a better platform ordered. I'm going to replace the platform this is on so it's not so precarious. So yeah, what did you think about Jules calling us, y'all? I've already got the live setup for tonight. Go to the live. Go to the live tonight. Go into the light. Go into the light. No, I'm kidding. That actually scares people. I shouldn't be doing that. I should know better. Really. Go into the light. Is this the link? I think it is. I'm going to try it out first. Yes. Okay. So I'm going to post the link here and comment. This is for tonight's live. Oh my God, Zach. Hi, how are you doing, everybody? How is everybody doing? Did anybody get some lunch? Did everybody get lunch? I'm typing, sorry. I keep doing it wrong. I'm sorry, you guys. I'm so sorry. I'm going to have to copy the shoot. I shouldn't have done that. I'm going to do this again. Oh, and it's going to be at 6:30. And I hope that's our food because I love our food. I'm hungry. That's what I wanted. So I'm going to delete this one, remove, and I'm going to remove, And I'm going to pin this one. Pin it. Pinned. Done. Done. We better be getting that. That better be my food. I think it is as quick as that was. I got to get my GoPro going. I'm going to put that over there so I don't get them messed up. So, okay, comments. I really need y'all's opinion. You're making quesadillas. Oh, yum. What is your opinion on this trial so far? Jules is not really thrilled with the attorney. I get where she's coming from. The attorney is definitely, um, thank you, babe. Kind of getting some stuff in there that she knows better. However, I'm liking the tea. I'm liking it. I really am. Hopefully this is the right drink. Yeah. My son likes root beer. Ugh. It's like drinking licorice. Ugh. No. As I say, gross. Oh, Sensei, come here. Here's your lunch. Come here. Go get it. So anyway, no, the kitty can't have your lunch. She goes over there and sniffs while the doggy eats. You are such an angel, beloved. Thank you so very much.
All the ketchup.
We don't have any regular ketchup?
No, we don't.
Okay. You want any of it?
No, I have some.
Okay. So, I'm really, do I believe she did it? Well, she said she shot him. Do I believe we have any kind of testimony to state that she was being DV'd? No, I don't see that. There has been no, other than someone stating she had a little bit of a, Matt, do we have napkins? Okay. So that to me is a little strange that we go there. I'm going to go get a napkin, y'all. Be right back. Excuse me, baby girl. Is that in here? I just got a Kleenex. Here. Oh, thank you. Oh, even better. Thank you. Okay, I'm back. Sorry. Oh, not fond of the defense, and I really don't like Benefield. Yeah, prosecutors. Okay. Well, one of the things that I'm struggling with this trial in general is the lack of lawyering. Okay, here's a crunch. There we go. The lack of lawyering. I can't say that very well. They just don't seem to have it together. They're not asking pertinent questions. I know, right? I mean, yes, there's things that are going on that shouldn't go on, but heck, we're getting some information wouldn't get otherwise. Yeah, the lack of questioning is what's throwing my mind. The mother, there's so much they could have asked that mother, unless there's something agreed to prior the motion in limine, but I don't recall. Oh no, I just didn't. Okay, I'm good. I don't recall hearing anything, but once again, I am doing it like an alternate juror, so I don't know too very much about it. But it gets me that they didn't ask any questions. So I want to put it to you. What questions would you have asked the mom that they did not? I'll take a bite. Got my witness list that my fabulous mod created. I couldn't do this. I couldn't do this at all. I don't know what's going on. Hey, Barb. So, what questions would you like to hear asked of the mother? My first one is, did you ever see any proof or evidence of domestic violence? Not hearsay. See it. Mm-hmm. 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 That's what everybody's wanting to know. Also, did the child appear to have any? And I found it very odd that the lawyer said that on his first visit with his daughter, he went and left with Ashley. That was insane to me. Mm-hmm. Mm-hmm. You know, usually when you have things like this going on, they're going to be late night phone calls. Did CPS interview the grandmother? How much time did the grandmother spend taking care of the child versus the mother? If you're ever in the Texas Hill Country, the little town called Kerrville, there's a place called Classic Hamburgers. Gosh, y'all, they're so good. I'm giving him a shout out. Leaving with Doug after the court for me is a sign that he was not abusive with her. If he was, why would she leave with him? Exactly. You're contradicting yourself. If you were scared of him and wanted a restraining order on him, then why did you leave with him and your child? Didn't make sense. At all. At all. And that's something I was thinking. If you're really that abused, why are you going with the man? That's a good point. I want to see the pastor, the young pastor. I know I'm eating fast, y'all. Oh, thank you so much, Trial Live. Thank you so much, Trial Live. The same thing for you guys. Y'all go subscribe to Trial TV Live. They are a wonderful YouTube channel, and they're growing. Reminds me, I'm going to go check out their growth. I'm going to go to their channel. Oh, they almost have 300, guys. They're 3 away from 300. Okay. Let me do this. Y'all go and subscribe. Please go subscribe. I don't know who this is. Hold on, y'all. I hate it when you answer the phone and it goes, whoop. Really? Yes, go subscribe to them. This is a wonderful group of people streaming court TV. No commercials, no people like me on it. Just court TV, court live. And I'm trying to get this eaten. I won't eat it all. I never can eat all my lunch. I don't have a big enough stomach. So I'm done. Oh, that ticks me off. Okay. Baby wipe. Because my keyboard and. Okay. I do want to talk. Oh, thank you for subbing. That's right. Y'all say I sub. I'm going to run that real quick now that we got more people. And we're going to get ready to hop into court. July has been an amazing month. And to end the month, we're doing a subscription campaign. And if you want to win a free Starbucks tumbler, just click the subscribe button. That's it. It's easy. Then leave in the comments, I sub, so we can get you in the drawing. The winner will be announced July 31st. Good luck, everyone, and thank you for subscribing. Welcome back, Miss Diane. Got you back on.
I'm back.
Lighting looks better.
Oh, thank you, ma'am. Working on that. Oh, gee, I did something to my hair. Now I messed it up. Life is good. Oh,
So, we have a deaf community who is wanting us to interpret the debates. So we need to know, when is the next debate?
and who is in it?
Guess.
I'm thinking it's probably the vice president and the running mate. Oh, Trump and Biden.
No, Biden backed out. It's Trump and Kamala
Oh,
Harris.
I'll do Trump if you want.
Nope,
Why not?
because I can hear his voice better than I can hear.
Nope.
No, it's pineapples, no politics. But we're sort of talking politics, but we just want to get it out there that we will be interpreting it. Yeah. I tried listening to her the other day and I really struggled. I tried interpreting her and it's like her pitch is out of my hearing range.
Well, I certainly hope I can hear her. And if I don't, I'm sure they will have closed captioning.
Oh, look, what Miss Kevin said, you got to nail the expressions.
I can do that really, really well.
So can
Yeah. You know,
we'll work on it and see. We can always switch halfway through if we need.
that'll work.
We'll see. We'll see that night if I can get the sound in a way that I can hear her.
Okay.
That's the issue, is being able to understand her.
Okay.
Yeah, I got to get nails put on when I do that interpreting.
Oh, I thought you had nails on. What happened? They off? They off? They were on. They off. You think I need any? My little naked men? Look, I gotta show you something.
Watch that. Watch those phrases.
Oh, okay. My little
Undressed nails.
undressed men.
Unclothed. That is so funny. You are so funny. You are a hoot.
My
You are a hoot.
men are there like this? Really?
Oh.
When my
Okay, here we go.
oh, okay, we're back. No, we're not back yet.
No.
When my kids were little and I did nails, I had a nail shop in my home. You too. I got that. And anyway, they always wanted polish. And of course, I would polish Mary's. But when I did the boys, this is what I would always give them
Oh.
with polish. And they accepted it. They'd walk around and they just talk to
I
their
didn't know that, Miss Kevin.
they would talk to their person on their hand. And now it is so funny because my daughter will do the same thing, except she has 3 girls. And so they constantly are having their nails polished. So anyway, that's how it goes. I'm sticking to it.
Yep. Yep. Well, Miss Morales, if your daughter, how old is your daughter?
Me?
No, Miss Morales, C. Morales. Because here's the thing, a lot of girls think they go to the beauty school and they want to do hair, nails, and makeup, specialize in one. And I got to tell you, makeup art, we have thousands and thousands of nail techs and wannabe makeup artists. But if she really wants to be a makeup artist, she needs to go to a school and get her license and certification and work on TV sets, movies. That's where you make money. There's not as many of those.
Impeachment argument, and then we'll get the jury. At this point, I've asked for the jury to remain downstairs in the jury assembly room. Just it's more comfortable. The chairs are more comfortable. They can spread out. They have vending machines and so forth. So, all right, it's your objection.
Specifically, I am objecting to the manner in which the defense is trying to impeach this witness. I just want to frame the issue. This witness's character or bias based on what we spoke about before. First of all, I would say character is never appropriate for impeachment. And I do have case law on point, but I think it's pretty clear that the only evidence of character that is allowed for truthfulness is reputation, and specific acts of untruthfulness are not allowed. So character, I do not believe, I don't know if the word was just used interchangeably, but I do not believe character has any part of this, and attacking character is not allowed. As to bias, I do not understand how what the defense is trying to do would achieve any bias. No ethical obligation or ethical complaint was ever filed. Even if one was filed, I don't know that that would be allowed to come in this case in this manner. I found no case law to say that that type of information could come in. But I also have objections to the manner in which this is trying to be done because, number one, Stephanie Murphy testified that the original petition for injunction had allegations in it, X, Y, and Z. Later, the defendant filed for, I think it was divorce, and alleged X, Y, and Z. I think what the defense is trying to say is that this attorney denied that allegation that was alleged in this petition after this attorney had been at Doug Benefield's deposition, implying that Stephanie Murphy knew different, but yet she still denied that paragraph of the petition. I have so many objections to that, but mainly I think even if that type of thing were allowed, this is like a motion to dismiss in criminal court where you admit a paragraph, you deny a paragraph. It sounded like she said that that paragraph, number 5, was 7 pages. So I can't imagine anyone agreeing to a 7-page recitation from the other side. So I do not think it stands for what the defense is purporting that it stands for. But even if it did, I do not think it's appropriate for impeachment.
Defense?
Okay, so here's what we know. And by the way, if I use the word character in referring to this, I was mistaken and I meant to say credibility. Here's what we know regarding Stephanie Murphy's testimony. She acknowledged that Ms. Benefield filed this domestic violence injunction petition, and she specifically mentioned a couple of the allegations. Or may recall, in particular, shooting the gun in the kitchen into the ceiling, punching the dog, and potentially suspecting that she was being poisoned. So that the court appreciates my position. The fact that she mentioned 3, my position is it opens up the entire petition. She doesn't get to limit it to just the 3 she chose to mention on her direct because the state called her, they opened that door. It's before the jury, I'm entitled to rebut it and probe it for credibility and bias. Now, with respect to what Ms. Murphy did or failed to do, she comes before the jury and announces herself as an attorney and that she's representing Douglas Benefield. She then responds to Ms. Benefield's petition where these things are alleged. This inappropriate conduct, abusive conduct, if you will. And she denies that paragraph in Ms. Benefield's pleading, specifically paragraph 5, that Judge White lists all the horribles, the domestic violence horribles. So it's our position, and so that we're clear as to how I perceive this should unfold, she then never corrects the record, regardless of whether it's a violation of a code of conduct, which I do think is impeachable, to show bias and favoritism, and to show failure to act within her expected realm of conduct. But in addition, 27 days later, she is present at the deposition of her client where he admits to all of these: shooting the gun, punching the dog, knocking the dog unconscious, punching holes in the wall, throwing a loaded firearm, I believe perhaps putting a tracker on a car, whatever it is, he admits to it. I am entitled to ask her why, in light of that, she never advised the trial court that her client admitted to this conduct and why she didn't bring that to the trial court's attention. She never did. So it's not that I am particularly determined to show that she violated the code of conduct, which again, I do think I should be entitled to ask, but merely to show that the trial judge, I will ask her this question also, trial judge wasn't at the deposition. So the trial judge never knew about these admissions. Now keep in mind, this is what she's presented to this jury. I am trying to rebut that. I am at least trying to cast doubt.
I think it's possible.
That witness's credibility.
He's making a good
I have
argument,
2 cases
I think.
in particular, in an effort to respond directly to Your Honor's request No, I could not find a case where a lawyer was called as a witness, and based upon cross-examination of the lawyer who failed to follow a particular code of conduct, impeachment was allowed. What I do have, however, is typical scope of cross-examination as it relates to professionals and as it relates to lay people. I want to mention the cases to the court, and then I'd like to read what I think is the relevant section. So the first one is Mendez versus State. It's a second DCA opinion. It's dated April 21st, 1982. They say in this
Can I
case,
have a cite, please? Page, not the cite.
page number is.
No, the whole citation.
So the whole citation is 412 Southern 2nd, 965.
Thank
The court says in this particular paragraph, cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test a witness's perceptions and memory, and to impeach that witness. And they cite United States versus Williams, federal case, Judge White at 592, Fed 2nd, 1277, Fifth Circuit, 1979. Limiting the scope of cross-examination in a manner which keeps from the jury relevant and important facts bearing on the trustworthiness of crucial prosecution testimony is improper, especially where the cross-examination is directed at a key prosecution witness. More important, and they string cite a bunch of cases to justify that, more important, a defendant should be afforded wide latitude to demonstrate bias or possible motive of the witness to testify as she has. That's the Mendez case. And in that instance, the witness was a layperson. It was an appeal of the conviction for attempted second-degree murder of a police officer. The court reversed the conviction based on what I just read, Your Honor. I also have, Your Honor, Roosevelt versus State. It's at 42nd Southern 3rd, 293. It's a 3rd District Court of Appeal decision. It's dated August 4th, 2010, Your Honor. This was a conviction
Cut to the
for
chase.
a sexually violent predator and commitment under the Jimmy Rights Act. It was reversed. It was reversed based upon the main question on appeal is whether the trial court erred in allowing the state to impeach the defense expert witness, Dr. Natalie Brown, concerning 3 separate matters. So in Roosevelt, it was a professional witness. She was a psychologist. The state was allowed to cross-examine the expert about an email that she sent while serving as a defense expert several years previously in a Florida criminal case. The state argued this testimony showed the expert's willingness to tailor her testimony to favor the party who had retained her and was therefore admissible to show bias. Here's what the court stated. Our evidence code liberally permits the introduction of evidence to show the bias or motive of the witness. Included within the types of matters that demonstrate bias are those that relate to the interest of the witness, favoritism, and corruption. Dr. Vicari's willingness to forge her interview notes at the request of the defense attorney could illustrate Dr. Vicari's corruption as a mental health expert. Therefore, because this line of impeachment could properly relate to the witness's bias, we find that the trial court did not abuse its discretion in permitting it. The last case I have to cite for the court is Russ versus City of Jacksonville. It is at 734 Southern 2nd 508. It's the First District Court of Appeal, Judge White, and it was decided
Somebody just
May
blocked
19th
Jules.
of 99. Court reversed and remanded the ruling for a new trial because the trial court committed an error when it denied the admissibility of information relating to the prior DUI arrest practices of the defendant's city's witness. So in this case, Your Honor, it was the impeachment of an officer. Turning to the merits of the appellant's argument, impeachment of evidence by the officer's prior acts. Turning to the merits of the appellant's arguments, the credibility, bias, or prejudice of witnesses who testify in a case, as well as the weight to be given their testimony, are a matter for the consideration of and determination by the jury. Where the credibility and bias of an officer is brought into question by virtue of that officer's past acts, impeaching evidence of the officer's past acts is admissible. As the Second District Court of Appeal explained in Mendez versus State, which was the first case I cited to Your Honor, quote, whenever a witness takes the stand, he by that fact places his credibility in issue. Cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test the witness's perceptions and memory, and to impeach that witness. The right of full cross-examination is
That judge
absolute,
looks
and the
so
denial of that
bored.
right may easily constitute reversible error.
Diane said the same thing.
I'll be happy to show you what the cases if you like.
I was
No.
familiar with Mendez and Russ. I'm well aware of those two cases. Those come up quite a bit. And Roosevelt, you've explained it. I'm happy to take them, but
Yeah.
it's up to you.
All right, so if the court's
Not
aware of it,
necessary.
I don't see any necessity. If Your Honor wants it, it's here for the court. My opportunity of Sixth Amendment right that belongs to Ms. Benefield to cross-examine
Driving me crazy.
is restricted when the court doesn't allow me to probe the story that she told here today. And that's going to include, respectfully, Your Honor, my then being asked,
What?
able
Kevin?
to ask Ms. Murphy, so I can try to save time here for the court and everybody else. In fact, did Douglas Benefield make these admissions at his deposition when you were present? And I propose to tick them off one by one. The reason for that is the court may recall that Ms. O'Donnell asked Stephanie Murphy what she observed, not only when they did the first exchange and how pleasant Doug Benefield was, but she concluded Ms. Murphy's testimony by having Ms. Murphy opine what a gentle, kind, and decent guy Douglas Benefield was. And I have previously given Your Honor a written memorandum establishing the case law that says questions such as, well, did you know, Ms. Murphy, that he admitted A, B, C, D? Yes, you knew it because you were present, are proper questions on cross-examination. If the court disallows that, the court has breached Ms. Benefield's right to cross-examination. And I might add, Judge White, in the interest of fundamental fairness, given her testimony, I should be able to ask her that.
Oh, breaking news. Update in the Ashley Benefield case. Over the lunch break, a woman came to a deputy saying she was a reporter. She had information about the case and wanted to meet with the judge. The judge told the deputy that the woman would need to come to court and speak in open court if she had something. What the heck? Yeah, if you don't have helpful, if you really don't have information, if you had good information, you would have no problem speaking before the court. Interesting. Thanks, Ms. Kevin.
Judge, and I'm confused about exactly what's being impeached. So apparently what the defense is saying is that because Stephanie Murphy said,
I apologize, there's more. She said she would not appear in court, and that was the end of it.
during the time that I dealt with Doug, he never overly expressed anger towards Ashley. I guess that's a new one. So apparently that now opens the door to showing that she knew other things. The question to her was, during the time that she was dealing with Doug and Ashley, what was his level of anger? Not what had happened before, not what she knew before. So I'm not sure that's how that opens the door when I ask her what the behavior was during the time that she dealt with Doug. So I'm not, and that's a whole different issue than all the case law we just talked about. I do obviously agree with the case law that you are allowed to impeach under the right circumstances, under the law, if the matter is relevant to credibility. I do not believe that any of this is relevant to the credibility of this witness. I believe that the defense is merely doing this for obvious reasons, trying to get in the admissions of Doug Benefield, which I dispute that he admitted things the way the defense characterizes them. So just by virtue of the fact that they're stated differently, I would disagree with their statements that he made. So I think that is what the defense is trying to do by labeling it as credibility and an attack on credibility. I think even if an attack on credibility was allowed under such circumstances, the specifics of these items would not come in. The fact that Ashley Benefield's petition for injunction listed 3 things does not open up Pandora's box where he can then impeach on the fact that the defendant admitted to those things. The court has already ruled that the state can generally talk about what the complaints were, that they were denied, and that type of thing. That's what the state did, generally talked about what the complaints were, and then that it was denied by the judge. So that's what the state did. I don't know how that opens the door to this type of attack.
Very briefly, Judge Mann, please.
All right, so
No.
I think from the first moment I had a hearing before you in this case, I have explained the procedures that I follow, whether it's a motion hearing, an objection, and that is the objecting party goes or the moving party goes, tell me everything you want to tell me. And then I go to the other party, the non-moving party, or the party in this situation that's the proponent, and I say, tell me every argument
In a little bit
that's in
side.
favor of you, and then I go back for rebuttal. And the reason I follow that process, and I've been very clear, and I've always followed that process, is because otherwise it'll just be back and forth and back and forth and back and forth. At some point, I have to make a decision and move on. All right. In this particular situation, as with all cross-examination, multiple factors are at play for any particular witness for impeachment purposes on cross-examination. Their perception, where they were, what they could see, what they could hear. There's 5 senses. Their memory of that, their ability to recall, their ability to communicate. their bias, any motivations they may have to testify a certain way, prejudices they may have, interests they may have in the outcome or a particular ruling, prior inconsistent statements, prior convictions. There's another number of avenues. And that's explained further in the case law. I have not been provided a case on point for this particular scenario. So as Mr. Taylor has astutely pointed out, whatever ruling I make may very well be the subject of an appeal to the Second District Court of Appeal. They may find I did something wrong or let something in I shouldn't or kept something out I shouldn't. And that's just the nature of trial work, the nature of being a trial judge and making decisions on the fly. But I'll frame this one up as best I can so it's ready for the appellate court. I find that the current avenue of impeachment of Ms. Murphy is improper. I'm going to sustain the objection. I find that it is improper impeachment to attempt to get in the victim's statements made in a deposition in a civil case unrelated to the criminal case through the impeachment of his attorney in the civil case based on an allegation that she violated a rule of professional conduct by not amending her answer to his complaint when it is alleged that she subsequently became aware of contrary information. I find that it doesn't provide any basis for impeachment under the existing case law. And this may be the case that says it does. All right. So are we ready to bring the jury back in?
Yeah, yes.
Before you bring them back in, just so I understand, so I'm
Dude.
precluded from basing my cross on the failure to conform to the professional code of conduct. Am I likewise precluded from probing her statement that Doug was a gentle individual and that the complaint that was filed was unfounded? In fact, if the court played it back, that was her characterization, that the allegations by Judge Moreland were unfounded.
I sustain that objection. So sustained. Are you ready to bring the jury back in?
Yes.
Ring the jury.
Yeah, I'm just asking right now,
Yeah.
are you ready?
Yes.
Are you ready?
Yeah, I would like to first make a motion. I move for a mistrial. I move for a mistrial based on the court's absolute and consistent denial of Ms. Benefield's right to cross-examine, and at every turn, the court's ruling adverse to the defense, despite the fact that the court has, under the same circumstances, allowed the state to be able to pursue it. I think individually, perhaps, it could be argued that they don't reach the level of reversible error, but I think cumulatively, especially given the state of mind that the court displayed in writing the order denying the stand your ground, where Your Honor fully stated that Ms. Benefield was guilty, I think we are seeing the result of that, and we are being denied not only right to cross-examination, but the right to a fundamentally fair trial.
Would you like to be heard?
Yeah.
Denied. You ready to bring the jury in? You ready to bring the jury in?
Yes.
All right, can you have Ms. Murphy step back in, please?
Oh my God, y'all.
Okay, excellent.
Man, it's like denied. Oh, I did that wrong. Got to do it right.
Denied.
Yeah. Oh my. Close. No, 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 no. You're bringing. Oh, I thought that was the jury. I was going to have a heart attack. We don't need another Karen Reed incident.
All right, Ms. Murphy, you can resume your witness seat. Ma'am,
He
I
is
will remind you,
fighting
you're
a
under
very
oath.
losing
I
battle.
also need to ask,
He
did
knows it.
anybody at all speak with you about your testimony or the questions asked? Did you speak with any of the attorneys? Did you speak with any other witnesses about questions they were asked or the testimony they gave?
No, none of those.
Did you watch any of the proceedings?
God, no.
Are they up?
Are we on direct or cross? Wow. Jules said it was going to get spicy. I'm looking for the, you can't see it. Let me put between your nose. But the guy, well, you couldn't see him. Her priest is, or pastor is in the room.
All right, y'all can have a seat. Welcome back, everybody. Hope you beat the crowd for lunch. Did anybody discuss the case amongst yourselves with anybody outside of this group? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about? Everybody says no. When we broke for lunch, Mr. Taylor was cross-examining Ms. Murphy. You may resume your cross.
Thank you, Judge White. Ms. Murphy, we've
It was a cross.
pretty much established that the homicide occurred on September 27th of 2020, correct?
That's my understanding, yes.
Okay, and then you've told us here today that Dr. Broder's report was set to be released 3 days later on September 30th. Is that correct?
Yes.
All right. And the inference by you in the state's theory is,
Objection?
Yeah.
so I'm sorry, Judge, was that overruled?
Overruled.
Thank you. The inference by you and by the state's theory is that Ms. Benefield then killed Mr. Benefield to stop the release of Dr. Broder's report.
Are you asking if that's what I believe or if that's what the state's inference is?
Well, you've discussed the matter with Ms. O'Donnell, have you not?
I have, yes. Yes, I have.
And in fact, she's provided you with all the documents in the case, hasn't she?
I don't know if she's provided me with everything, but I have gotten a lot of documents in the case.
By direct conversations with Ms.
Yes, I did a
O'Donnell. Okay.
discovery request.
And so is the implication not that, as you testified before the jury earlier, Ms. Benefield shot and killed Mr. Benefield because of this report that was coming out by Dr. Broder 3 days later?
Absolutely, I have no doubt.
Okay, so that's the theory of the homicide.
Right.
All right, so I want to pass you some emails, see if you recognize them.
Wow.
Can we approach?
Yes.
That's huge. I know. I'd love to be in that courtroom right now, too. We don't have these kind of trials here. I would love to have a copy of them, but we can't. Our county doesn't live stream. It kind of sucks. How was my sound, Miss Kevin? So, defense lost big on this one. However, I wonder if they're going to get this in. The defendant looks more engaged. She looks more alert. She looks a little more
Oh, wait.
awake, not so coward, shy, dramatic. I'm sure her attorney listened to some of these broadcasts. Lives, not broadcasts.
So I would like to pass these documents to you and let you just take,
Okay, he won.
take your time.
She looks good even with glasses. Dang. This lawyer, I'd say she's late 40s, took really good care of herself. Is that better, Miss Kevin? I'm not as excited. Wonder who that girl is directly behind Ashley. She still looks a little pitiful, but not so pitiful. One reason why she couldn't get into a ballet company is she was too tall. An ex stated, the defense lawyer is trying to rival the YSL trial in motions for mistrial. So she is tall for a ballerina. I mean, 5'6" at least. That's pretty tall, but she's very thin boned, lightweight. So you think the lawyer's 32?
Okay, so I have
No,
a
baby.
series of simple questions for you. Do you want to reconsider whether or not the release of Dr. Broder's report was set for 3 days following?
Oh, Ashley? Yeah, she's in her 30s.
It was agreed with,
Do you want to,
no, I'm not going to
Answer.
revisit that.
you can answer and then explain if you like. I'd like you to first answer.
I'm not revisiting the answer. My answer is the same. It was set for the 30th, 3 days after.
Okay.
And I can explain further if you want to hear more.
Yours.
No, that's fine. As long as you've reviewed that, it refreshed your recollection, I trust.
Hello, Miss Emma.
It does. I don't think it's a complete
That's all.
conversations, but yes.
Okay. Now, is it not a fact that Dr. Broder, on the 3 days following the event, was on vacation?
What event? The murder?
Yes. The 3 days following the event that this report was to be released, is it not a fact that Dr. Broder wasn't in town? He was on vacation.
I don't think that's correct. I think he was on vacation the week prior, but I don't know. I try to remember everyone's vacation, but this was a lot of years ago.
Is that document in front of you contain emails between you and?
Objection. Relevance.
Ooh,
Does that document that you were holding contain emails between you and Judge Moreland's judicial assistant?
As well as other people.
But that's not what I asked you. I asked you, does that document contain emails between you and Judge Moreland's judicial assistant?
Not only, but yes.
All right. And you still maintain, after reviewing that the hearing was set for release of Dr. Broder's report.
Dr. Broder was returning from his vacation on the 23rd. So if you look back
Not
through the emails.
not responsive to my question,
Objection,
Your Honor.
Judge Whitaker.
She's editorializing. I asked her for a simple answer. She can feel free to explain it after if the court feels that's appropriate.
also stated, he called for a yes or no.
No, and that's why I'm saying she's, okay.
No, it called for a yes or no, so
Oh, okay.
your objection,
Is sustained. Got it. All right, so is the answer to my
He
question?
can't keep up with his own stuff.
Yes,
Can you repeat the question?
I knew you were going to ask me that.
Well, I want to be
Well-
accurate.
Can I ask the court reporter, Your Honor, to read the last question back?
go ahead, ma'am.
She's not going to make it easy. And I know Jules doesn't like her.
After reviewing that.
But it makes good drama.
The release of Dr. Broder's report.
Yes.
Now, could we agree if Dr. Broder was out of town and not available, and the court would not entertain the hearing unless Dr. Broder was present, would we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly, because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation. I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
And it's your testimony then that the hearing would have taken place?
Had he been alive, yes. On the 30th, not the
Yes.
23rd, which is what I think you're
All right.
confusing.
You referred to a letter that you sent to Ms. Benefield on March 14th, 2018.
My memory is that it was the 15th of March, but if you have it, that would certainly help. And do you have the email that was sent with it?
Andrea,
Not the letter that I sent.
whoa. I thought we were here to show support for the victim and not for the drama.
This is a draft of a letter.
Mhm.
The letter that I sent on the 15th
This is
was
court
on my
drama
letterhead.
I'm
so this
talking
is not
about.
the letter.
Okay.
It's getting
The
spicy.
letter that you did send on the
Yes, we're here to
15th,
support the
I think you
victim.
told us, if I'm not mistaken, was an effort by you on Doug's behalf to advise Ms. Benefield, among other things, that he wanted to try to work things out.
No, I don't think that's correct. No, that's not what I said this morning, nor was it the intention of the letter. And I don't have the actual letter I sent to verify, but there was nothing about reconciliation. The letter was about whether she would agree to him being present for the birth of his child,
Okay.
what was supposed to be the next month.
All right. So you sent the letter to see if she was willing to have him present for the birth of the child.
Yes, that's right.
We're in agreement.
Yes.
All right. Were you aware whether or not there was any prohibition at the time that you sent that letter from Douglas Benefield coming in contact with Ashley Benefield in any
That's the
capacity?
clip of the day.
I'm aware that there was an injunction that was entered by mutual agreements. It was what people refer to as a mutual restraining order out of South Carolina.
Correct. And it was in effect at that time, was it not?
It was. They would have had to
So
have
that-
a written agreement modifying that.
So that would have prohibited Mr. Benefield from being present with Miss Benefield, would it have not?
No, I don't have the South Carolina order in front of me, but my recollection.
do.
Oh, that would help if I could see it then.
May I, Your Honor?
You may approach, yes.
Here's the transcript, here's the order.
Your client killed my client is the phrase of the day.
Of the transcript.
Well, the date of the hearing was November 3rd,
November
2017.
3rd. And you were aware that the order was entered for a period of 6 months, correct?
Didn't you hand this to me for me to look at? Okay.
Oh my gosh, y'all. This is getting funny. Not funny, haha. This is interesting. I find it, I love watching a lawyer on the stand. This is good. How often do we get to see a lawyer on the stand being crossed and showing a little bit of attitude for the person crossing her?
Okay, so what's the date that the hearing takes place?
The hearing took place on November 3rd, 2017.
And at that hearing, Doug was present.
It appears so, according to the order
All right.
that was entered.
What year?
And
10
if
days
you-
later.
If you look at the last page, I believe paragraph 2, the judge orders.
I'm going to object to going through this hearsay piece of paper.
Are we only talking about the order?
Right now, she's looking at the transcript.
No, this is the order.
Okay. the
Oh,
order.
If it's a court order and you're asking the witness to interpret it, I think that's okay. I think she's demonstrated that she has sufficient experience, training, and knowledge.
All right. So the hearing concluded on the 3rd.
It appears that it did. I wasn't there.
Yeah.
This was before my time.
But you were aware of that when you sent the letter to Miss Benefield. In other words, you knew you were sending the letter because Mr. Benefield was not allowed to communicate with Miss Benefield. Wasn't that why you sent the letter?
No, that's not why. Maybe that's why he didn't send her a letter, but that was not the reason why I sent the letter. I sent the letter so that it was a formal request, not in between the two of them directly.
Would you agree that had Douglas Benefield asked that of Miss Benefield, it would have been in violation of that order?
Sustained.
Let me pass to you, if I can, this document.
oh,
I did not. I don't know.
Oh, sure.
I need you to show it to opposing counsel before you show it to a witness.
I thought you had a copy.
how long? Dude, how freaking long have you been practicing law? Really? You've been practicing law how long? And you can't. This is not the first time you've had to be corrected on very basic law or legal procedures. You know better. What just happened, but I got it. We got you.
Where did everybody go?
No, it's okay. It's a glitch. We got you. See, we're good. But get your crap together, dude. You're a professional. You look like an idiot. I'm done. Okay, we're back on.
'30th.
Did you know whether or not Doug Benefield sent a package to Miss Benefield in November of 2017?
I don't remember the date. I know that he did send her a package before this order was signed, but after the hearing took place in South Carolina.
Okay, so after the judge ordered no contact, he sent her a package.
My understanding is that Doug did not really understand what was going on at this hearing. And Ms. Benefield was even chastised by the court for manipulating that system.
Well, thank
and
you
so-
for adding that. Let me just ask you a question. What is it about you may not contact Miss Benefield that you think Doug didn't understand? By the way, Doug was there and heard the judge say it. So enlighten us, please. What do you think it was about you may not contact Miss Benefield that Doug would not have understood?
Doug did not have the court order when he went to buy her birthday present. He told me that the negotiations about this mutual restraining order took place in the hallway outside of the courtroom. But I wasn't there, so that's just what I was told. And we had the time that he received this order from the judge, from his attorney's office, and it was after he sent the package.
Okay, so this report by Broder, the one that you acknowledge and the state suggests is the theory behind the homicide, Miss Benefield had signed a voluntary agreement to participate in that evaluation, correct? It was not court ordered. Isn't that what you told us?
It was not court ordered in the
Okay.
family law court.
So
I don't
she
know what she signed.
She voluntarily participated.
You know, I don't know. You're going to have to talk to the Manatee County Sheriff's Office because it came out of that office or the CPT office.
Well, you were the lawyer for Mr. Benefield. Was your client ordered to participate?
I don't know that we're in agreement with the word ordered. So when I think of an order, I think that a judge has ordered people to do something. And so we had filed a motion for a psychological evaluation in the family law court. And so if that judge had signed the order, that would have been an order. So my answer is I don't know if either of them were ordered to participate.
You're not aware of any commandment that either Mr. Benefield or Miss Benefield participate in Dr. Broder's evaluation.
It's my understanding that they were both required to as part of the investigation with the Manatee County Sheriff's Department.
Give me just a minute, Your Honor.
Yes, sir.
Yay, Braxton! Thank you. Oh my gosh, my first gifted membership. How did that work? Oh, Braxton, you're so sweet. Now what?
Please.
That's bad when I don't know what. Thank you. Means Braxton has basically sponsored someone's membership
Are you
for the
asking for a
month.
moment?
Yes,
I guess YouTube.
please.
I guess YouTube. Oh, that's a cute badge. Oh my God, that's so cute. Miss Kevin, you remember too. Oh my gosh, that's so awesome. Thank you, Miss Kevin. Why isn't it showing up? Oh, it was Miss Kevin who got it. Oh, the computer automatically. Oh, that's awesome. Thank you, Braxton. That's so awesome. I got it now. I'm learning. We all learning, y'all. Yep. Okay, so YouTube randomly
one
picked
last
and it
shot
got
at
to you.
this.
Cool. Diane, you have to have your
Yes.
your thing turned on. I'll help you do it so you can get sponsored. If you want. Well,
My coffee thing.
did you get it worked out?
Well, it works for me. You said it doesn't work for you.
Nope.
I'll erase it, start it again.
Does that document have any impact on your position that the release of Dr. Broder's report was scheduled for September 30th?
It was scheduled for September 30th. We knew before the weekend that the hearing on the 30th was going to address the joint motion to release the psychological evaluations. Ms. Brown and I had extensive discussions about that because Ms. Benefield was agreeing to dismiss her petition.
Ms. Murphy, I'm sorry to cut you off. Is the answer to my question no, that it doesn't change your position?
It does not change my position. It was scheduled for the 30th.
Well, when we say scheduled for the 30th, is it not a fact that the only hearing that was to take place on the 30th was everything other than Dr. Broder's report?
If you
Is the answer to my, let's get a simple answer. Is the answer to that yes?
I don't have the docket. So I guess the answer is I don't know what the docket says. All I know is
You
it was
did not
scheduled for the
know.
30th.
Objection, Judge Lynn.
You trying to make this,
All I know is that that was supposed to be addressed on the 30th of September.
and were you not told on the 30th September that the only issue that would be heard was the
Objection
domestic,
asked and answered.
was the domestic violence injunction? That's what I'm asking you. Is the answer to that yes or no?
Initially, that was what we were told. That was not the case by the time we got to mediation. The situation had changed.
Yeah. And do you have any documents that you brought here today to support your contention and the state's theory that the release of this report was the incentive for Miss Benefield to kill Douglas Benefield? Do you have any documents that show that that correspondence with the court's judicial assistant was wrong, and that
Objection, compound question.
and that the only matter being heard
We just hit 100 objections in 2 days.
was
Objection,
not
compound question.
101.
not the domestic violence injunction?
Sustained.
Do you have anything that supports that the release of Dr. Broder's report was scheduled for the 30th?
I don't know what documents you got from Ms. O'Donnell's office. However, I did provide emails.
Do you have any documents here today?
I didn't bring anything, nor was I asked to.
Okay,
You should
so
have
you
the
knew,
emails.
wait, you knew you were coming to court to testify before the jury in a homicide case,
Objection, badgering.
Wouldn't answer your question.
that the incentive for Miss Benefield to kill her husband was the release of this report on the 30th. You don't have anything to support that other than what you've told us?
Sustained.
That's all.
Don't, sir, you have one more paper. Mr. Taylor, don't forget.
Can't even get his paper back. Dude, collect your crap.
All right, redirect.
No questions, thank you.
Can this witness be released?
Yes.
Absolutely not. She's under our subpoena.
All right, ma'am, you remain under subpoena. As I said before, same rules on sequestration.
Cute purse.
You cannot discuss the questions asked of you or your answers with anyone, including the attorneys. You can't talk with any other witnesses about what happened in court or what their testimony was or the questions asked of them. You can't hear anything that's going on.
I don't think I was subpoenaed by Mr. Taylor's office.
Okay, well,
She's released from March.
all right. Mr. Jury, can you step out, please? I'll answer this legal question. Remember, don't begin your deliberations or talk with anybody outside the jury. Don't do any research on people, places, things, or legal topics you've heard anything about.
Snap. Diane likes that one. Look at Jill's back there. She's like, "Ooh, this is good. I'm glad I came today."
You all can have a seat.
I wonder if there's going to be admonishments happening.
Subpoenas for depositions and trials in the old days had to be procured from the clerk, which is obviously a branch of the court. That was changed many, many years ago to allow attorneys to save time and effort and money for everyone involved, where attorneys of record were granted the authority under the Florida Rules of Criminal Procedure to issue subpoenas for deposition and trial. I would imagine if we pull them up, and I'd be happy to take a look at it, I would imagine that the subpoena that was issued is for the court.
I would have to look this up.
My position is when a witness is subpoenaed to court, and the reason I ask each and every time, can this witness be released? Because I believe witnesses are subpoenaed by the attorneys on behalf of the court. So whether you were subpoenaed by the state or the defense is of no moment to me. I asked,
No.
could you be released from a subpoena? The state said yes. The defense says no. That's all I need. So Ms. Murphy, you are not released from your subpoena.
Thank you.
The obligations regarding the rule of sequestration in Florida statutes applies to you. Thank you.
Thank you.
He didn't like her asking that at all. He didn't like that at all. Not at all. That was a little bit of a snark on her. Oh, look at her. She's like, I'm out of here, man.
All right, the witness has been excused. Mr. Taylor, you wanted to approach, but the jury's out, so I figured might as well just take care of it now.
Sure. So now I would ask that the court issue a subpoena to Judge Moreland's clerk. The court may recall that we had an in-camera hearing where the court quashed the defense subpoena to Judge Moreland's JA and told me that there were better ways that I could prove my case and that the court shudders to think what would happen if every JA were subpoenaed. What the court's just witnessed is Ms. Murphy lied flat out about the reason why Ms. Benefield feared release of that report, and my impeachment of Ms. Murphy indisputably is going to come from Judge Moreland's JA, who told Miss Murphy in the emails that I handed her and showed her, the only thing that is set for hearing on September 30th, 2020 is the domestic violence injunction. Nothing else will be heard. In fact, I'm going to read for the record. I'm going to read the one sentence email that was sent.
The reason I'm going to stop you at this point is you're referencing arguments that were made in camera. The state was not present at your request in order to preserve trial strategy of the defense.
Yes.
Present at that hearing, when we stepped back into the jury room, was myself, a court reporter, Mary Ann Floyd, the general counsel for the 12th Judicial Circuit, Mr. Taylor, and Ms. Benefield. The state was not present. They didn't have an opportunity to be heard or know these issues.
Export take.
Now the issues are being brought to light in order for them to have a fair opportunity to understand the issues and be prepared to argue against whatever motions the defense may make. I certainly think due process requires they're entitled to notice and opportunity. I would do the same for the defense. If there was some issue for whatever reason that I had considered in camera or ex parte for the state, and whatever reason the need for the privilege or confidentiality no longer existed, prior to having a hearing on that issue and requiring the defense to respond to it, I certainly think at a minimum, notice of the issue and an opportunity to be heard. So right now, they don't even have a copy of the order that I signed that you just quoted from, Mr. Taylor, and they have no idea what you're talking about because they have not seen that order because I ordered it to be sealed.
Yes, if the court will allow me, I'll elaborate. And I would like to read the
He
email.
sealed it.
The issue that you seek to have heard right now, I am happy to hear it. However, it is not a pressing matter. You seek to have a witness subpoenaed in order to present, I would assume, during your case in chief.
Yes, sir.
We could certainly address that issue at the end of the day after the state has had a chance to review that order. And I don't recall if the motion. No, the motion itself was public, but then we had the in-camera hearing and my order was, I sealed it.
Yes, sir.
So
We had the email chain also as an exhibit.
yes, so the email chain is an exhibit. There were two exhibits actually. I can't remember what the other one was. And then we had my order. So I'm going to need to unseal those things so you have you can get copies of them.
I remember what the other one was. It was her prior testimony from the stand ground hearing.
It was excerpts from the
Same.
stand your ground hearing, excerpts of Miss Murphy's testimony.
Right.
That was exhibit 2.
Correct,
Or
saying what she said today.
Okay.
So the only thing, if I may, that I want to supplement today's record with is I showed Ms. Murphy an email dated September 18th of 2020 at 10:18 a.m. It included between her and the judicial assistant for Judge Moreland. And it says as follows: "Good morning, Ms. Murphy and Ms. Brown. Per the judge, she will not sign an ex parte order for release of psychological evaluation and report. The judge will allow an expedited hearing on this motion. I have available Wednesday, September 23rd at 9 a.m. for 30 minutes. However, besides both attorneys being present, the judge has stated that Dr. Broder and Manatee Children's Services must be present at the hearing as well. Further, Ms. Murphy, the judge stated that absent showing where the court granted permission for the other motions stated in your September 17th letter to her, the only matter being heard on September 30th is the injunction hearing.
And that is part of the email string that's one of the exhibits. All right. So like I said, I don't think it's appropriate to hear this right now. I think the state has every opportunity and should be allowed to review my order and the two exhibits.
Just, can I just be heard real quick?
I'm sorry?
Can I just be heard briefly on something?
Of course.
Now, or you want me to wait?
Go ahead.
Okay. I don't know if, because I'm unsure what Your Honor is referring to, because we haven't seen it, the seal. I don't know that any of the things that Mr. Taylor just showed to Ms. Murphy were ever provided to the state in discovery, which is one issue. We received a defendant's exhibit list that was unnumbered and in no particular order. It has 391 items on it. I spent more time than I should have trying to organize it in some fashion, and I do not believe that any of those emails were ever provided to the state in discovery.
Wrong.
If they were, I'm still speaking, sir. If they
No.
were, I would just ask if somebody could give me the name, because I numbered them, but it has 391 items on it, and it's some of them have multiple things inside of them, and they're not named anything that you can understand. So I'm just asking that if in fact they were provided, if we could, the items that were shown to Ms. Murphy, in addition to what Your Honor has said, on seal, please.
All right. I'll let you two work on that,
Okay.
and I will look forward to having a Richardson hearing at the same time that we have the hearing on the defense request for me to reconsider my order quashing the mechanic trial subpoena.
Okay, guys, that was not very fair of me. We were having our own side conversation, and this is fair and equal access. Basically, I, I was talking to her about the presidential debate that's interpreting, because I think it will open up more doors. It's fun to watch, though. Yeah. Do you know what's fun to watch? Deaf people eating and talking at the same time, and we never stop eating. Faster. We can talk and eat at the same time and not be rude and get through quicker. Okay, guys, talk to me. What is your thoughts right now? What are your thoughts? I popped off. Say that again.
Ate for lunch.
What
I
did we
ate
eat for lunch?
grits and eggs.
Ugh.
Oh, wonderful. Wonderful.
Grits.
Oh, I love, grits they're wonderful. If you cook them right. If you don't, they're nothing. But if you cook them right, they're really, 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 really good.
My grandma, I was so underweight, so no one cared how much sugar and fat I got. She put so much butter and sugar and brown sugar and raisins in mine like an oatmeal.
No.
I still didn't
No.
like it.
No, I put butter and salt, pepper, and eggs in mine. And my kids still love grits.
All right. Who loves grits?
Me, 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 me.
Gross. Gross. No, thank you. Oh my gosh, this is taking forever.
Yeah, well, they're busy.
Sealing the prior order.
There we go.
Quashing Vicky Mechanic's trial subpoena, unsealing the 2 exhibits that were admitted by the defendant during the in-camera hearing, and unsealing the notes and transcripts of the court reporter that was present for the in-camera hearing. I'll sign that right now. That'll should happen pretty quickly, and state you'll be able to get copies of that, and we'll see if we can have this argument by the end of today or first thing tomorrow before we get started. On the defendant's request, Ori Tennis motion to reconsider order quashing, and the state's Richardson hearing. Would you, or I can state the other ones. Yeah, do fine.
Man, it's gotten quiet. Everybody got quiet that time of day. The after lunch snoozies have hit. Time for a little kratom called 1836 Logic. It has white kratom powder, mushroom blend with lion's mane, chaga mushroom, cinnamon, and nutmeg. Great for natural like energy. Oh God, no. Oh, I always slept when my kids slept in my arms. I couldn't help it. Most relaxing thing. Diane, you need to check your coffee account and see if you have a privacy setting or something after you're done with the live.
Oh, I can do it. I can just make you a little littler. How do I
Okay.
check my
If
coffee?
not, you may have to contact them
Okay.
because I need to transfer that.
Here's your next witness.
Oh, I Detective Chris Gillum.
All right, go ahead and bring the jury in.
Detective who? Did you hear the last name?
Nope. They don't talk real clear sometimes.
Well, at least I know it's a detective. See, I have to type all this
yeah.
up.
I don't remember how to check it.
I don't know. I can help you later.
All right.
I'm drinking so much water, I have to keep going back and forth to the little girl's room.
Have a seat. Welcome back, everybody, as you're finding your chairs. Anybody talk about the case back in the jury room, talk about the case with anybody outside the jury, or do any research on any of the things we talked about? Everybody says more. State, call your next witness.
Detective Chris Gillum.
I'm sorry, sir. Affirm the testimony about to give the truth, the whole truth, and nothing but the truth.
I do. Hello, sir. My name is Judge White. I'm presiding over this case. Just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right as you need. And just speak in a loud, clear voice and it should pick up everything.
Yes, sir.
Good afternoon.
Good afternoon.
Please state your name.
Chris Gillum, Gillum.
Where do you work?
Manatee County Sheriff's Office.
How long have you worked there?
22 years.
And did you work somewhere else before for several years? How many years?
Yes, City of Palmetto Police Department for 12 years.
Okay. And what position do you currently hold at Manatee?
I am currently a domestic violence investigator.
And how long have you been in that unit?
12 years.
How, I said in that unit, but if you could just describe, does Manatee County Sheriff's Office have a unit for domestic violence?
Yes, we do. We have 4 detectives.
Okay. And where and how is that unit housed?
We are housed at our building is the 3500 block of 9th Street West is the actual address. And within our building, it's my unit and the crimes against children detectives as well.
Okay. Were you in that same position back in 2017 to 2020?
Yes, I was.
Okay. Back then, did your department house child protection services?
Yes, at that time we did.
Okay. And explain that. Were they with you in the same area or how did that work?
No, they were on the other side of the building. We had our own area and they were on the completely opposite side of the building.
And were they actually employees of the sheriff's office?
Yes.
Did you do a lot of stuff with them together? A lot of investigations together?
The domestic violence unit, we did not. Every so often, that was mostly the crimes against children detectives that worked with them.
And as a domestic violence detective, have you investigated violations of injunctions and that type of thing?
I certainly have.
Okay. Now, sometimes when someone is asking for an injunction, or when an injunction is violated, it can be charged criminally, correct?
Correct.
Okay. Or they can take other avenues
That's
to
correct.
address the violation. But you're not involved in that other avenue if it's a different court, correct?
Yes, I'm not involved in that.
Did you become familiar at some point with someone named Ashley Benefield?
I did.
And when was that?
December of 2017.
Generally, what were the circumstances without it getting into a lot of detail?
She reported that her husband violated an injunction that was in place out of South Carolina.
Okay. And that came to you?
Correct.
And we've heard several mentionings of poisoning. Did this have to do with the same issue?
It was the same case, yes, but I had nothing to do with that investigation.
Okay. So the poisoning itself, you didn't have any contact with. It was just the violation of injunction.
Correct.
Did you speak to Ashley?
I did.
How many times would you say you spoke to Ashley?
I think a fair number would be 30 to 40.
Okay. And generally speaking, was that because you were contacting her or she was contacting you?
No, she started contacting me on a regular basis beginning around February of 2018.
Okay. And what was she contacting you about?
She was wanting to know the status of the case and when Doug would be getting arrested for the violation of the injunction.
Okay. And when you do a violation of injunction, when you're investigating a violation of injunction, you can do several things, correct? You can, well, explain what you can do with it.
We can make a physical arrest in the case. There could be no charges filed in a case, or we can send the case to the state attorney's office.
Okay. So if you send the case to the state attorney's office, what does that mean?
We're just letting them make the ultimate decision if they think there's enough for charges to be filed in this case.
Okay. So it sounds like there's no charges and then arrest and
Sustained.
so you said Miss Benefield was calling you asking about the arrest of Mr. Benefield.
Yes.
Okay. And what did you tell her?
That the case was still suspended at that point, and when I had an answer for her, I would let her know.
Okay. And so that was the beginning of your conversations,
Yes.
right? So, did she continue to call
Yes, repeatedly, twice a week at least.
and speak to you personally?
Yes.
And what was her comments? What were her concerns?
It was the same thing. When was Doug going to be arrested for violating the injunction?
Had you ever told her that he was going to be arrested?
I did not.
At some point, did you decide to forward the charges?
I did.
And is that to the state attorney's office like we talked about?
Yes, it is.
Okay. Did you inform her of that?
I sure did.
Okay.
Welcome, Lulu
What was
Hurt.
her reaction to that?
She was upset that he was not being arrested.
Were you able to explain to her that the process and how this was going to go?
Sustained.
Were you able to explain the process to her?
Yes, I was.
Okay. And how did she take that?
She was not happy that I was not placing Doug under arrest.
At some point, did you speak to Ashley Benefield again? And she told you about a court hearing?
Yes.
Approximately when was that conversation? you
Around
had?
the first week of May 2018.
May 2018. And what did she say?
She just got right into the phone call and requested that I arrest Doug for a hearing that was coming up in Manatee County.
Okay, you just said arrest for a hearing.
Yes.
But arrest at a hearing?
Yeah, said that there was a hearing, upcoming hearing in Manatee County.
And was that hearing involving your case or something else?
It was something else. It was not my case.
Did you know that there was a hearing or there was even a court issue going on?
I did not.
So she told you there was a court hearing, and did she tell you when it was?
No, that just shows there was an upcoming hearing, and she asked for me to arrest Doug when he came inside the courtroom in front of the presiding judge.
Okay. And what was your reaction to that?
That absolutely would not occur.
Okay. And how did she take that?
She was upset. And at that point, I would call it a dramatic cry, hysterical cry started happening. And I'm still informing her, we're not going to do that. We're just not going to arrest him in the courtroom. And she made a comment, something to the effect of that the judge sees you arrest him, this will help me keep my baby. So I thought that was a pretty bold statement. I'm like, I'm still trying to give her the benefit of the doubt. She just gave birth. Maybe she's confused. And trying to explain to her gently, that's just not going to happen, especially not going to happen for a judge to see to help you in a civil matter.
And did you in fact explain all that to her?
Yes, I did.
And how did she react?
We went back and forth 5 minutes or so. Just kept requesting to arrest him. I said, that's not going to happen. And her tone turned from the crying to very aggressive. And she says, you will effing arrest him in front of the judge and I will make sure you do it.
What did you say to that?
I started pushing back a little bit and I said, it's not going to happen. Whatever you say or do, you cannot make me arrest somebody in front of a judge, and it's just not going to happen.
And what did she do?
I guess she started crying again and came out with a comment, something to the effect of, I can't believe you're willing to allow Doug to kill me and the baby.
Okay.
And that hadn't come up in this phone call. That the phone call dealt with me arresting Doug in front of a judge. And then it turned to arresting, or not arresting him, and allowing me to let him kill her and the baby.
Okay. So that seemed kind of different to you
Yes.
than what you had previously been doing.
Yes.
Okay. How long did this conversation go on?
20 to 30 minutes.
Okay.
For up to that time, it's probably 20 to 30 minutes.
Okay. And during this time, excuse me, did the defendant ever seem to understand the process of what you were saying?
No.
And at some point, did she change from crying again?
She did.
What did she do?
It just abruptly changed and she let out like a screech or a high-pitched scream. And she says, I'll do whatever I have to do to kill my baby or keep my baby, you a-hole.
Okay. So it's a high-pitched scream, or did you say scream or screech?
Like a screech at first, but it was I'll call it a screech.
A screech.
Yeah.
And tell me, what volume is this?
I could just say it's a very loud, maybe top of lung type scream.
Okay. Could you demonstrate to us?
It's impossible. There's no way I could.
Why would it be impossible?
I couldn't get my voice that high. There's no way.
So it was loud and it was high.
Yes.
And she said, can you repeat what she said?
I will do anything I have to do to keep my baby, you a-hole.
You a-hole. And did she say a-hole?
No, she said the full word.
Okay. And after she said that, what'd she do?
At that point, I had checked out of the phone call and I was pretty much ready to hang up the phone on her. And she accused me of conspiring with Doug to get her baby taken away.
And had you even spoken to Doug about custody of the child?
No.
Okay. Were there other detectives around you at the time of this phone call?
Yes, there were two other detectives.
And do you recall their names?
Oh, yes. Detective Patricia Hetrick and Detective Brian Moreland.
And did they appear to recognize that you were on a difficult call?
Oh, they did. And at one point, Brian even asked me if I needed some help.
Sustained.
And at some point, how did the phone call end?
Ms. Benefield terminated the phone call.
And you seem to have a good memory of this call.
Yes.
And why do you have a good memory of this call?
Because in my 12 years of doing this, I've never had anybody ask me to arrest someone in front of a judge inside of a courtroom. Now, I have had people call me before and say somebody may be appearing in court that I'm looking for so I can arrest them, but I've never had somebody say, wait until he's inside the courtroom in front of the judge.
Thank you. No further questions.
Ross?
Oh, this ought to be good. We'll see.
Just a moment.
Wow, what do y'all think now? It's starting to sound a little La Coco.
Afternoon, Detective Gillum.
Good afternoon,
Coco
sir.
Cabeza.
I want to ask you a few questions about report writing.
Sure.
Do they teach that to you in police academy?
Sure. Back in 1989, they did, yes.
Okay, it's obviously an important part of police work.
Sure.
How many cases would you say could you average that you handle in a month?
20.
Okay. And over the course of a year, we're talking about
300 closed.
So are you familiar with the saying that they give you in police academy, if it's not in the report, it didn't happen?
I've heard that before, yes.
All right. And that's because the report is obviously more reliable than your memory.
I could understand that, yes.
All right. At 20 cases a month, 2.5 years later, you're into like 600 cases. If you got your report, you can refresh your recollection rather than have to recall off the top of your head.
Sure.
Which is why you want to put critical details in your report, because that's what you want to remember.
Correct.
Not necessarily that somebody had on mismatching socks, but that they had something that's significant to the investigation.
Sure.
All right. So your initial involvement, you told us in the case, is speaking with Ashley Benefield on or about May 31st of 2018 regarding the domestic violence injunction in South Carolina.
That wasn't the first time I spoke with her, no. There were several incidents I spoke several times I did.
Did you speak with her on or about the 31st
I
of
was
May?
prior to that.
Okay, about the South Carolina injunction.
Yes.
All right. And just to be clear, we're talking about the same thing. There was a court that had issued an injunction in South Carolina, stay away from one another.
Yes, in South Carolina, that is correct, sir.
Okay. Now, at some point, did you bring any of the reports that you wrote with you here today?
I did.
Do you recall how many you wrote?
Supplemental reports, 3 or 4.
Yes. All right. So initially, if I can ask you about the sequence of these events, Miss Benefield had gone down to the Manatee County Sheriff's Office to complain about a package that she received because it came while the South Carolina injunction was in effect.
Yes.
All right. And it would have been Deputy Wesley Weber, to your knowledge, had requested a capias based upon Miss Benefield's receipt of that package.
Correct.
Just so the ladies and gentlemen of the jury understand, a capias is
Objection.
arrest warrant.
Testifying. And
Sustained.
it's all hearsay.
What is a capias?
A capias is information where a deputy believes that there's probable cause for someone's arrest.
All right. And that was issued by Deputy Wesley Weber.
Correct.
And that would have been on December 14th of 2017.
That sounds correct.
Oh, you're still alive.
Now, a month later, well, actually, several months later, on May 31st of 2018,
Objection. I called for hearsay, but I apologize. I'll let him finish the question.
did you write the first of your supplemental reports?
Yes.
And in that report, you stated that Miss Benefield,
Objection. Hearsay.
Sustained.
in the report, did you indicate,
Objection, hearsay.
Sustained.
did you write anything in your report in describing,
Objection, hearsay.
Can you approach, please?
hold on, let me have one more shot at it. Did you document in your report anything different than you told us here today about how you characterized Miss Benefield's demeanor?
I didn't go into any details in that supplement at all, in that one.
May I show him the report?
Y'all, I wish he would have made the screeching, screaming. I would love to see him mimic that.
Judge, can we?
Yes.
Alrighty then.
During that time, Detective Gilliam, back on May of 2018, you overrode Deputy Wesley Weber's capious request, correct?
I did.
Okay, and you put the case on an inactive status.
Yes,
And I think you decided, as you told us, it would be submitted to the state attorney's office.
that is correct.
Now, on June 5th of 2018, you interviewed Douglas Benefield, did you not?
Correct.
And he admitted to you.
Objection, hearsay.
Sustained.
We're up to 108
What was
objections.
his
Jeez.
position with respect when
Oh,
you
thank
asked
you, Lulu.
him,
Objection, hearsay.
Finish the question.
did you send the package to Miss Benefield?
Sustained.
Did you make a determination from your conversation with Mr. Benefield whether or not package had been sent to Miss Benefield?
Objection, relevant.
Can you ask the question again, please?
Sure. Did you make a determination as a result of your investigation whether a package had been sent to Miss Benefield?
Yes.
Did you make a determination as to who sent it?
Yes.
Who?
Douglas Benefield.
Did you make a determination of what the contents of the package were?
It was a tea set.
And was hazmat called?
Objection, Josh. Hearsay.
Sustained.
As part,
Did you say hazmat?
yes, sir. As part of,
Sustained.
As part of your investigation, did you make any determination whether or not there was a response by
Objection, hearsay.
any other agency to this package that was sent to Ms. Benefield?
Objection, hearsay.
What? What?
Sustained.
Look at Jules with a slight smile.
Did you tell Mr. Benefield that you would be able to unfound the case if he sent you the receipt?
Objection, hearsay.
I'm
Oh
asking him
my God.
if he told Mr. Benefield.
Can you please approach?
Did you tell Mr. Benefield?
Can you please approach? Can you please approach
Oh,
the bench?
Ooh, I'm gonna. Oh, snap. Okay, I'm gonna play this. Oh my God, y'all. We did it. I can't believe it. We actually did it. Exciting news. Memberships have launched. Memberships are a great way to financially support this channel. Starting at the juror level of membership, we will be hosting members-only lives. Also, at the judge level, we will be having VIP events. We hope you will enjoy sporting the membership badges and soon to come exclusive emojis. Thank you for watching and supporting the stream and my dream to provide accessibility to the deaf and hard of hearing. Ouch. Oh man, this has been a little snippy to today. Today. I feel in order me to turn the hearing aids up so I can hear anything at all, I then hear my part of my voice, not all of my voice. It's kind of sketchy and it gets a little difficult to talk when I can hear them and me, and it's hard. But oh my gosh, y'all, this is interesting. So everybody, welcome, Miss Ronnie, wonderful mod. Oh, Sneaky Side, welcome. Lulu Hertz, welcome so much. Look forward to following everything with you. Not in a good way, I guess. I don't know how to say that without sounding tacky. I pray the best for you. Okay, here they come. Let's see what happened.
I think the last question I asked you was, did you tell Douglas Benefield you could unfound
lost
the
it.
case if he sent you
Vince won.
the receipt for the sending of this package of tea?
Mm-hmm, Miss Kevin.
No.
I thought he'd say yes.
So did you write a supplemental report as a result of this interview with Mr. Benefield?
Yes.
And this would have been on June 5th of 2018.
That's correct.
Now, did you put and document in that report anything about Miss Benefield?
I would have to look. If you don't mind, I can certainly.
Please.
No, I don't see anything about Ms. Benefield in the supplement.
Okay, you did determine though that the package, once you got the receipt, you determined the date the package was sent.
Yes,
And that was on when?
November 27th, which is when the injunction was signed off on by the judge. It was the
Yeah.
same day.
But you also determined that the hearing on the injunction was November 3rd,
That
2007.
was the hearing, but the judge did not sign off on this until the 27th, which was the same day. So
Right. But at the hearing, Mr. Benefield was present when the judge announced.
yes, when he announced, but it was
Okay.
my understanding it's not in effect until the judge granted his signature on the 27th, which is the same day that Mr. Benefield sent out that T-set.
Okay, who is the lead detective in this case,
For which case?
for the homicide case?
I'm not sure.
Is it Detective Warren?
I don't know.
Do you recall contacting Detective Warren on November 30th, 2020 at 7:47 a.m.?
I do remember contacting him. I'm not sure if that's the date, but yes, I did.
Okay. And do you now recall that Detective Warren is the lead homicide investigator?
I'm not sure if he was the lead. I know that he was at that scene, but I'm not sure if he's the lead investigator.
Okay, so you talked to Detective Warren on that day.
Yes,
You then, 16 days later, Detective wrote another supplementary report, correct?
I'm not sure if it was 16 days later. I would have to.
Why don't you take a look and
Sure.
see if that report isn't 16 days following your contact with Detective Warren.
And when did you say I contacted Detective Warren?
You contacted Detective Warren on September 30th, 2020 at 7:47 a.m.
Yes, I entered a supplement on October 15th, 2020.
Okay. Now, following your conversation with Detective Warren on that day, September 30th, 2020 at 7:47 a.m. in the morning, you write a third supplement, do you not?
Correct.
And it's dated October 15th, 2020,
That is correct.
16 days after speaking with Detective Warren.
That is correct.
In that supplement, you list, do you not, the details of what you described today about how Miss Benefield behaved.
That's correct.
So let's make sure we understand this now. This is 2.5 years following the discussion that you related to the ladies and gentlemen of the jury of Miss Benefield's response. 2.5 years later, you remember the details of the conversation
Absolutely.
and exactly what she said. Quotes, you quote her.
Yes.
But you never mention one word of it in your supplement that you wrote on June 5th of 2018.
You are absolutely correct.
Y'all, I've been on scenes
Nothing for,
and places where I've had conversations with people and they were so freaking erratic and crazy. I remember them almost word for word now, but I didn't put it in my report back then.
let me just check.
Really? When it's such a unique and bizarre situation, sometimes you remember those.
Okay, that's all. Thank you.
Redirect?
Why didn't you add that information to your supplement back in 2018?
In my initial supplement, which was May 31st, I did put in that supplement that she demanded an arrest be made in the courtroom when he appeared. At the time of my interaction with her, I didn't see anything she said at that time as a direct threat to Doug. It had no relevance to my case. I saw this as her just having this massive meltdown because she wasn't getting her way with me. So at that point, it was just not relevant for my case. There was no reason, but circumstances have changed. I thought that's information that needed to be heard.
So, and what circumstances?
Obviously, Mr. Benefield is deceased at this time. And her words at that time may have had an entirely different meaning. I did not take it as a threat. I took her saying that I'll do whatever I have to do to keep my baby, you a-hole, as my manipulation attempt for the court system. Not that she was going to create any harm to Mr. Benefield. Now, she never mentioned anything like that. She was never any threats. But I just took that as a manipulation attempt. When she wasn't getting her way with me, it was a meltdown. And there was just no reason for me to put that in my supplement that she was having this massive meltdown because I wasn't going to buy into it.
And so after she murders Doug Benefield, you thought it was relevant,
I thought that was very relevant information that needed to be heard.
And did you reach out to someone about that?
I did.
Or did they reach out to you?
I reached out to him.
You reached out to Detective Warren,
Yes.
correct? Okay. Thank you. No further questions.
Did Detective Warren direct you to write this up?
Absolutely not. I wouldn't take orders from him to begin with.
And 2.5 years later, you remember that she said
Get off of it already.
specific things. This will help me keep my baby if the judge sees you arrest him, quote unquote.
Yes, because it's a very, very bizarre comment I've never heard before in my career.
That's like 600 something cases later.
That's fair.
That's all.
Heck, like the lady
Okay,
who
did you
answered
release
the door.
subpoena?
Yes.
So you're releasing your subpoena. You're free.
Like the lady who answered the door, and I told her husband deceased, and she said, "Excuse me a minute." Went in her kitchen, got 3 glasses because it was me, a sheriff, and her, and a bottle of champagne. Popped it and came back and was celebrating. I remember exactly what she said.
That means that you cannot discuss with anyone your testimony here today, the questions that were asked of you.
Word
The
for
attorneys,
word.
Parties, anyone else. You can't talk with other witnesses about
Her
their
words
testimony,
were,
the questions that were asked.
"Hallelujah, that
You can't watch
is
any of the
dead,
proceedings that
and
are
I'm
going on.
free."
Are still sequestered pursuant to your subpoena.
Yes, sir.
State.
State calls Detective Brian Moreland.
You sound sure of what the testimony you're about to give will be the truth, that is true for them.
Hello, sir.
Hey, how are
As
you,
the
sir?
deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches away from the microphone. It does adjust up, down, left, right. And if you're speaking a loud, clear voice right at the microphone. it'll be-
Exactly,
Thank you, Your Honor.
Miss Kevin.
Good afternoon.
Good afternoon.
Please state your name.
Detective Brian Moreland,
How do you spell both names?
BRIAN MORELAND.
And we've had some testimony about a Judge Moreland. I just want to make it clear. Is there any relation between you and Judge Moreland?
No, ma'am.
What is your employer?
Manatee County Sheriff's Office
How long have you been there?
since 2004.
What is your current position with them?
I'm a crimes against children detective
How long have you done that job?
since January 2011.
And crimes against children, is it known by an acronym?
CAC,
CAC. Okay. So if you hear CAC detective, that's what we're talking about.
that's correct.
All right. So you've worked in that capacity for several years. So you were working in that capacity between 2017, 2019.
Yes, ma'am.
What does the CAC unit investigate?
Any crime that involves a child, any crime against a child, I should say. Sexual abuse, physical abuse, malnourishment cases, things of that nature.
And we heard that your office, you share an office space with other departments.
Yes,
And what are
the
those? departments?
domestic violence unit is also in our office.
Okay. And back then, 2017 through 19, there was another entity in there with you. The child protection services, were they in your?
Oh, I'm sorry. Yes, DCF was in there.
DCF. Okay. I apologize. The letters have changed over the years. So,
Obviously, yes.
all right. Did you do a lot of investigations alongside specifically DCF or child protection services is what I call it?
So being in a crimes against children unit, we often work very closely with other agencies, DCF especially. My job as a law enforcement agent is to investigate crimes, basically. The child protection investigators, their job is to protect the children and offer services when needed.
Okay. So they have different goals.
Correct.
All right. When there's an allegation of child abuse, just generally, what is the protocol? To who investigates, who gets the information? Like how does that go?
Generally, a report will come through the abuse hotline. Law enforcement gets notified, and DCF or child protection investigator will get notified, assign the case, and go out. And we usually do that in tandem.
Okay.
So we're all there at the same time, and like we said before, different goals.
Different
When we
goals, but
get
you're
there.
there at the same time,
That's correct.
typically. Okay. And sometimes reports can come in, someone can just walk into the station, correct?
Oh, yeah.
Or call or do something
Yes,
like that with the sheriff's
and
office.
if we get it first, then that deputy, whoever's writing that report, can contact the abuse hotline.
Okay. So I want to talk about, well, first let me ask you about Detective Gillum. So you said you're with the domestic violence unit.
That's right.
Do you know Detective Gillum?
I do.
Have you worked side by side or at least in the
We've
same
worked in the
space?
same office for many years. Yes.
And he just testified about a phone call that he had that he remembers quite well.
Yes.
Do you recall him having a interesting phone call?
I remember the phone call.
Okay. Were you sitting there?
We shared a cubicle wall, so we couldn't actually physically see each other, but we could hear obviously everything that was going on.
Okay. And did this seem like a typical phone call that he?
He seemed quite exasperated at the end of that phone call.
Okay. At the time, did you know who Ashley Benefield was?
Yes.
Did you later become involved with Ashley Benefield with reference to CAC?
Yes.
And around December 2019, were there several investigations that came in, started a series of several investigations that came into your department?
Yes.
So I want to ask you about the first report or the first investigation. About when was that?
Can I refer to my report?
Sure, go right ahead.
December 10th, 2019.
Okay. And generally speaking, what was the complaint?
Judge, based on prior motions and we.
Yes, sir. I understand. Go ahead.
Thanks, sir. This investigation involved allegations of sexual abuse.
Okay. So
What?
sexual abuse, obviously, of a child.
Yes, ma'am.
And who was the child?
Emerson Candy.
And who was the complaint against?
Douglas Benefield.
Objection. Oh, I'm sorry, withdrawn.
Is it the same objection?
No, withdrawn.
Go ahead, ma'am.
So did you get assigned to the case?
Yes, ma'am.
Right. And so just as a matter of procedure, when you initially, when Manatee County Sheriff's Office gets a case, you're not initially assigned right away, right?
No.
What happens before you get it?
Generally, what happens in cases like this is, however we receive the report, whether it be through the hotline, whether it gets reported directly to the sheriff's office, a uniformed deputy along with a child protection investigator will go out to the scene. The uniformed officer will normally write the information down in a report, and that information gets filtered through our supervision. And if it needs to be assigned, it's assigned.
Okay. So theoretically, on this particular complaint, there had been some work done before you got it.
That's correct.
Okay. And then did you continue that investigation?
Yes, ma'am.
And as part of that investigation, was Emerson sent to the child protection team?
Yes, ma'am.
And what is the child protection team?
The child protection team is a state-funded team that, for
Same objection, Your Honor.
Sustained.
for my criminal investigations.
Sustained.
Oh, I'm sorry. Sustained.
Like you can hear me.
Okay. Did you talk to Douglas Benefield?
Yes, ma'am.
Okay. Did you also speak to Ashley Benefield?
Don't recall if I spoke with Ashley on that particular case. I believe she was interviewed already.
Okay. And what did you do with the case? Were any charges filed?
No, ma'am.
So I want to talk to you about the second report, and that was what date?
Report date was March 21st, 2020.
Okay.
March 21st.
2020.
Generally speaking, what was that allegation?
That was a physical abuse allegation.
Okay. Physical abuse against,
Douglas Benefield.
and the victim of that would have been?
Emerson Candy.
Okay, same parties.
Mhm.
And how old was Emerson at the time, approximately?
2 years old.
And again, the same question, had some things been done before you got the case?
Yes, ma'am.
All right. Did you continue that
I
investigation?
did.
And at some point, did a second complaint come in before you were finished?
On the 23rd of, so March 23rd, 2020. Yes.
Okay, so a couple days later.
Mhm.
And what was this complaint?
It was again physical abuse.
Different than what came in a few days before?
Yes.
Okay. Did you investigate those two things together?
I put them in the same report.
And what did you do with those cases?
No charges were filed.
And I'd like to talk to you about the third report. When did that come to MSO, or when did you get it?
April 5th, 2020.
Okay. And generally speaking, what was that allegation
Physical abuse.
of Emerson?
Yeah.
And by Doug
Douglas.
Benefield?
Yes.
And once again, before it was over, did you get another complaint?
On the 27th, another deputy responded.
And what was that complaint?
Again, physical abuse.
Same parties?
Yes.
Did you again investigate those two case numbers together?
Yes.
And what did you do with those cases?
No charges were filed.
At some point,
God
were
almighty.
you a part of what's called a staffing?
Yes.
And what is a staffing?
Staffing is when the entities, as I mentioned before, come together and try to find a good way, or moving forward, a good way to protect the child.
Okay. And did you attend a staffing on this particular case?
The plethora.
The Benefield, yes. And as a result of that, were Ashley and Doug assigned to go to therapy with Dr. Broder, or not therapy, an evaluation with Dr. Broder?
Yes, ma'am.
Okay. Thank you. No further questions.
Cross?
Yes.
Lord Almighty. Y'all, I hate it when people abuse the system like this. It
Just a
pisses
few
me off to
questions
no
for you,
end.
Yes, sir.
Detective Moore. The cases that you referred to, I think you said there were 5 of them.
Yes, sir.
I don't want any details.
Okay.
Those cases have to be reported, correct?
Yes,
That's how they're initiated.
that's correct.
And would it be safe to say that in this case, the reporters, without any names, the reporters were,
Objection calls for your second.
Go ahead, finish your question.
reporters were not all the same.
That I wouldn't know. I'd have to go look.
Do you have the reports with you?
I do have the reports with me. I
Why
don't
don't you-
know. I don't know if it's going to tell me who the reporter was.
Something-
Whether
Somebody clicking something over here. If you are, please stop.
I don't,
Go ahead.
I
Come
don't
here.
want to know names.
Okay,
Hey,
Okay.
can you, puppy, puppy, puppy?
Names are confidential, are they not?
that's correct.
Okay. I just merely want you to tell us whether or not, in fact, the reporters were different individuals. Would you search your,
I can look. I don't think the reports
Yeah.
are going to tell me, but
Judge, I would object.
A blanket, and a boy, and a beach.
Right now, the question is just,
whether the reports were from different
Oh.
individuals?
You're growing.
Yeah, 8 weeks today.
8 weeks old.
He's so smart. Oh my God. You know the antlers that you gave me that Quincy?
My dog is jealous. She's like, Mommy, love me. You love the puppy. You gotta love me. We're babysitting our friend's puppy for the afternoon. Well, hello. Oh, she's running around. Hi.
He's a fighter. So keep an eye on him.
Uh-oh. Kitty, kitty.
Yep.
Matt, you gotta put the cat up.
Thank you.
Bye, Kathy.
You wanna say hello, Sensei? Say hello.
definitely.
Oh.
Did you at any time personally interview Ashley Benefield?
Never seen the cat do that before.
I honestly, I may have. I don't recall if I ever interviewed Ashley. I know I interviewed Douglas quite often. Initially, when I get these cases, the
Did
Uh,
you? I'm sorry.
interviews with her were already completed. So.
Did you at any time personally interview the child?
No.
I don't believe I have anything else. Let me just check you on.
That is a golden lab.
That's all.
Um,
Thank you.
Redirect.
Bastrop, Texas. It's
believe
not
you
mine, it's our
said-
friend's.
With respect to, did you interview Ashley, that you said by the time it gets to you, a lot of times those interviews have been done.
That's correct.
And that would be by who?
Uniform.
Uniform. And then he asked, did you interview the child? Do you normally interview children?
No.
What is the protocol for children?
Forensic interviews are done by child protection team.
Okay. And so generally speaking, you wouldn't say you interviewed children?
No.
And was this child of an age to be interviewed anyway?
No.
Okay. No further questions.
Sir,
That's all.
can this witness be released?
I'm sorry.
Can this witness
Yes.
be released?
Sorry.
Mr. Taylor, can this witness be released?
Yes.
Sir, you're hereby released from your subpoena. You're free to go. Thank you. Thank you.
It's very unusual. They've not been agreeing on who can be released.
We got back a little bit early. It's now, I think, a good time to take our mid-afternoon break. It is about 2:50. So how about if we take, we'll probably end up being about 15 or 20 minutes. So you can go back to the jury room. You're free to use your phones. If you need to send or receive texts or emails or phone calls, just don't talk with anybody about the case amongst yourselves or anyone else. But of course, as we discussed, don't do any research on the people, places, things, or legal topics you've heard anything about. Stretch those legs and we'll see you back in a little bit. All right. Jury's out. You can have a seat. State looking at the list in front of me. 1, 2, 3, 4, 5 more on the list.
Yes. I have a question about that.
Yes.
So we've had Dr. Vega kind of on hold. And so I don't know how far we'll get with these next 3 witnesses. I could have him come here, but my question would be is if it was gonna take us past 5, if he comes, can we still do it? He's very busy and I hate to take up so much of his time. Or would Your Honor rather, because I know you wanted to feel some other things, would you rather me tell him first thing in the morning? I know you don't know how long these witnesses are gonna come. Take.
I could tell the court that Dr. Broder is going to be up there for a while.
And so I just don't, my question is, if I have him come, can we deal with him today? Or do you think once we hit 5 o'clock, if it's beforehand, you're gonna wanna go home? Which I understand either way.
Yeah, I would imagine that if it starts pushing 5 o'clock, we'll probably break and start again tomorrow.
Yes, sir. Okay. Okay, that's the schedule, that's all I have.
Okay.
I do have something else, if you don't mind, not as scheduling. So the clerk was kind enough to unseal your order, but the items that were attached are evidently in that room locked up. And so I just don't know how we could get a copy because I haven't seen them. And so I just want to address it with the court of how to get a copy.
The evidence clerk is making copies.
Oh, good. Perfect, thank you. Thank you, Judge. Thank you.
All right, anything before the break?
Break.
Yes.
Oh my goodness. I think Jules will probably call RA first, which is reasonable. But I'm wondering, I'm going to listen. I'm going to listen. And oh my gosh. She's on. Oh my wow. Oh my gosh. Okay, let's talk about the conversation that was had between the deputy and the detective and Ashley, where she was demanding that he would arrest her husband in front of the judge in court to help her get her child. The jurors are reporting to be very stoic, non responsive, watching, but not talking to each other, not reacting, just very flatline. Well, Jules is saying that the two women in the front kind of started nodding and responding. It lit a little fire under their butts, is what she's saying. That's when the note taking started. Wow. They weren't taking notes before that witness. Now they are. I I believe that that just shows that they believe in his testimony. They're accepting his testimony as the truth, and they believe that he's trustworthy. I mean, there's manipulative, but oh my god, is that manipulative. I cannot believe that somebody would sit there and demand a deputy sheriff arrest their spouse in court. Insane. Well, I'm hearing the jury is hard to read. So she's saying they could go either way. Wow, wow. We'll see if she can have time to give us a call. If not, we will definitely be hearing from her at 6:30. Miss Diane, if you wanna come back, that's fine. That's 7:30 your time. If not, that's fine. I understand you've been doing it all day. 7:30 your time tonight, I'm doing a live with Jules. We're having an exclusive live with her, but you don't have to hop on if you don't feel like it. Yeah, that's pretty much it. I Borderline personality much? There's something going on with this woman. Something going down with this woman. Yay! Oh, good news, Miss Kevin. But understand, it's we can't really diagnose people. I'm being a little sarcastic, but sort of serious. There is some odd behaviors, and I would love to see what the psych eval says. I want to hear the results of that psych eval. Oh, the puppy's barking. Forgive me if you hear it. But I think the jury is lost now with the defendant. I'm going to shut the door. Y'all ought to see this. It's so funny. Oh my God. It is so funny. Okay, my dog has never been around puppies. She's always been around dogs her age as she grew up and until now. This is the first puppy she's been around, and she's not too sure what to do. It's so cute. Okay, what's being said here? She has some nerve to tell y'all at the detective like a... Oh my God. She does have some indications of a BPD. However, yes, psych eval would be interesting. Trained professionals sitting in the same room with her. What's her name? That Karen, who was that lady that was hopping on that was a therapist? I haven't seen her for a while. Oh. Mm-hmm. Mm-hmm. Yeah. There was a hearing that was scheduled, and the person who performed the psych eval was on a vacation, but it was being argued as to when the vacation was and when the hearing was and all of that kind of mess. And to me, it was just jabs and pokes by the defense trying to impeach the witness, but I don't think he did. That report has to be bad if her lawyer is trying to say they weren't going to even cover it on the 30th. I think that's very much a plausibility, and it's a coincidence as to when this situation occurred in conjunction with the court and when this court report was going to be made public. My biggest thing is, okay, she wanted away from him. Why didn't she just leave? Why did she end life? But if she thinks she's going to lose custody and all of that, I'm starting to see the reason, the motive, possible motive. Yeah, I didn't feel comfortable with Mama either. Mama was not a good witness for her in reality. I don't think Mama was a good witness at all for her. Oh. I'm looking. So if you come, I'll send you the link if you want to come back tonight. If you don't, you don't. If you do, you do. I'll send it to you. Bye, love. Love you. Bye. Thank you. Shame. So, Miss Kevin, should we make the announcement? Should you make the announcement or should I? Yeah, her mom will probably take custody of the little girl unless they deem her not appropriate. But I think his parents are too old. Okay, good news. All right, sounds like a plan. Oh, we've got some stuff going on tonight. Y'all need to come to our live tonight at 6:30 my time, Central, 7:30 East, and 5:30, West, yeah. And we will be announcing something, and we will also be hopefully getting more subscriptions for this drawing. I mean, who does not want a free Starbucks tumbler? Not sponsored, for the membership. Not membership. Subscription. For subscribing. You're putting a drawing. When you say I sub in the comment, new subs, if you say I sub in the comment. What? Did that puppy come after you? Did that puppy get you? She came in here like, Mommy, get me away from the baby. What? Baby Luke is a new painless? What's that? Uh, so, well, I might as well run it. Might as well. I'm having so much fun in Canva learning how to do all this. I'm going to beef this up. July has been an amazing month. And to end the month, we're doing a subscription campaign. And if you want to win a free Starbucks tumbler, just click the subscribe button. That's it. It's easy. Then leave in the comments, I sub, so we can get you in the drawing. The winner will be announced July 31st. Good luck, everyone, and thank you for subscribing. Y'all, I am enjoying making these little reels. Yeah, I'm like, panelist. Oh, oh, we'll do that. We'll do that. I am hot, I'm cold. I'm hot, I'm cold. I'm hot and cold. I don't know what it is, man. Well, this computer I have here is like this wide, that deep, yay high. It's huge. Weighs freaking 50 pounds. But it puts out heat. It puts heat out. And so this room gets hot pretty quick. In the winter, it's going to be great. But right now, not so great. Right now, not so great. This is driving me nuts. Maybe that did it. My arm that mounts my camera is not the best, so I've got to get a new one. What, Matt? Come here, baby. My sons are like, Mom, I'm trying to get the puppy to come here. Yes, I remember that smell. I remember that smell all too well. Yes. When I lived in California, we had a bunch of milk cows, but they had farms. Man, when that stuff started to spread, whew. And then the smell would go away, and then you have a rain, and then it would be again. We just learned to live with it. We just learned to live with it. Where's the baby? My poor dog's over here. Get me out of here. Get me out of here. Oh, what was I gonna look at? Yeah, y'all, I was pretty flustered over the situation with the daughter. Somebody talked to me about that yesterday. Oh, I'm sorry, Karen F. Aw. Yep. So I'll be bringing a baby on for a bit if you guys all go to the stream right now. Yeah, bring him on. Bring on the baby. Oh, come on, bring the baby. We want cutes. Oh, we gotta go. Oh, we gotta put thumbs up on the screen. Well, I guess I can go to my own screen and like my own stream. You know, I can do that. Right, we got 14. Ooh, did it. We did it. Oh, we have been having a lot of fronts coming through here, and it's giving us headaches. Well, okay, I'm gonna be in little girl's room. Right there. Okay, Miss Kevin. Well, guys, I am going to be having some announcements soon, but I will say this, and I know I was going to tell Miss Kevin about it, but I better wait and talk to Miss Kevin about it. But I want to do something, and I want to make a contest out of it, and we're going to see what happens. Uh-oh, looks like we have an accident. Puppy had an accident. Puppy in a new place. Puppy gets confused, and that's perfectly fine. Puppy, that's okay. That happens. Puppy's never been here. Well, was here the first day she came, but she's not, this is new to her, so she's learning. But I want to do something good. I want to have a competition. Because see, this isn't just my page. It's all of our page. It's a community. And I want you guys to feel like you're involved in some of the stuff that we do here. So I will share it tonight. So come on live tonight. I will share it. He's babysitting our friend's puppy while she has I think a doctor's appointment or something. And it's okay. Babies make mistakes. That's the way life is. My cuticles and my hands are so dry. It's horrible. So anyway, we are growing and I want to start branching out a little bit. One of the things I wanted to share with y'all is I have other channels. I haven't done anything with them, but one of the channels I have is a makeup channel. And I have had a lot of women tell me they don't know how to do their makeup. They never were taught. And I thought, wouldn't it be nice to do a YouTube live where people can call in and ask questions? Because a lot of times you don't get to ask questions. You just sit there and you watch and you don't get to participate. So I have next door, I have a full makeup studio. And then I also have my studio in here for the YouTubing, but I can do it both ways. But the phone calls would be better happening in here. And I want to possibly talk about different skin types and face shapes, which everybody talks about, but I'll really break it down a little bit more. Want to talk about different skin conditions and things that we all deal with, and some of us who've had cancer, what works, what doesn't work, etc., etc. And that's going to be on my AdaKay, your MUA. Oh, I love animals so much. If my husband let me, I would be a hoarder of them. Oh, we will. We will. So that is the name of the other YouTube page that I have. Yay! Where are you? I don't see you. You haven't hopped in yet. We're waiting. Doing one. I'm going to go ahead and get some background going. Oh, they're coming back.
All right, we're back on the record. State ready?
Yes.
Defense?
Yes.
All right. Let's go and bring in the jury.
I went into the wrong live stream. I was like, oh, that's one for tonight.
Hi, baby boy. But he can't hear me. Oh. Someone just woke up from a nap. Someone's a happy boy.
Say hi to all your fans.
Well, see, Morales, go to that page and subscribe and click on the bell so you'll know when I post. I have no subscribers on that page. 0. Oh, I know. Isn't it cutie?
Just threw up in my hand.
Been there, done that. I'll see you later. So been there, done that.
All right, y'all can have a seat. Welcome
This-
back,
this-
everybody.
The puppy is running, my son.
Deliberations amongst yourselves, talk with anybody outside the jury about anything about the case, or do any research on people, places, things, or legal topics you bring on.
No, sir.
Everybody says no. Call your next witness.
State House Dr. Brad Broder.
You saw this girl from.
There's people on their list that's not on mine.
Yes, I did. Thank you.
Cool, so
Good afternoon, Judge.
my name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. You want to be about 12 to 15 inches from the microphone, so you can probably scoot up just a little bit. Adjust this left, right, up, down. And just in a loud, clear voice, you should pick up everything. So really breathe.
Fair enough.
Bless you.
Good afternoon.
Good afternoon. Judge, just for the record, we renew all prior objections.
Yes, sir. Overruled.
I'll put the link up in a
Please state your
second.
name.
Brad Stephen Broder,
How do you spell your last name?
Broeder.
What is your profession?
I'm a psychologist, clinical psychologist licensed here in the state of Florida and in New York State.
And how long have you been a clinical psychologist?
I got my PhD in clinical psychology back in December of 1986.
And when did you move to Florida? I think you said New York. You were in New York
Correct.
before.
I first practiced in New York and relocated here in the summer of 96. I was licensed here by February of 1997 and have been practicing here ever since.
And do you have your own private practice?
Exactly. I'm a solo practitioner.
Okay. Do you also do some, what I would call consulting work for the child protection team or child protective services?
Yes, I've been a consulting psychologist to the Sarasota County Child Protection Team since the summer of 1999, and several years later was hired as a consulting psychologist by Manatee Children's Services, which is their name for their child protection team. Pardon me. And recently have been contracted with the Fort Myers Child Protection Team. That's just as of this summer.
Okay. And can you just briefly explain what are your duties with reference to being a contractor for the child protection team? What do you generally do?
Well, through the Department of Health, each county in the state of Florida is supposed to have a consulting psychologist on their team. And that is for several reasons. One, it helps out with supervisory cases if on an as-needed basis, as well as once or twice a year, there's supposed to be in-service trainings where you conduct seminars, do presentations to help the staff there. But primarily it's to attend the multidisciplinary staffings, which they're asking the consultant to come in and discuss, you know, a certain case, what might be going on, if you have any kind of impressions or recommendations. Based upon those kind of meetings, then sometimes the psychologist myself would be asked to conduct an evaluation.
Okay. And ultimately, were you asked to conduct an evaluation of Doug and Ashley and Emerson Benefield?
I was specifically asked to conduct psychological evaluations on each of the parents, both Doug and Ashley, but not their child, Emerson.
Okay. The child was pretty young, correct?
2 years, 4 months to be exact, during the time I did the evaluation in the summer of 2020.
Okay. So you started the evaluation about when? You said summer, but
I believe it was June 1st to be exact when I first met Ashley, and the next day I had met Doug for the initial intake interviews.
okay. And what was the general goal of these interviews? You eventually were going to report back, I would assume, to the entity that hired you.
Yes, each psychological evaluation is meant to be submitting a report with diagnostic impressions and recommendations based upon the data that's been collected. The evaluation is based upon whatever the CPT recommendation was, meaning referral for the recommended evaluation. In this case, Manatee Children's Services had specific questions about each parent.
Okay. So and your evaluation is generally focused toward the best interest of the child. Would that be a correct statement?
Yes, absolutely.
Okay. So you said you first began this around June 1st of 2020.
That's correct.
Did you ultimately complete evaluations of Doug Benefield and Ashley Benefield?
Yes, I did.
Okay. And as part of this evaluation process, did you review documents?
There's a series of steps in any thorough psychological evaluation, which includes collateral data, which is both defined
break.
as interviewing other people as well as reviewing documents. Yes.
Okay. And did you do that? You reviewed documents?
If I may, I just brought the reports along with me in case I had to refer to them. But yeah, there was
Sure.
a series of documents reviewed for each of them.
Okay. And we don't need to get into specifics about what the documents were, but you did review several documents for each of them.
I certainly did, yes.
Okay. And what is a collateral interview?
That's when I asked each person to give me a couple names of people that they think understands their situation best that I could contact and call and just do kind of a phone interview. If possible, obviously a face-to-face interview is preferable, but based upon where people are situated and located, sometimes it's just easier to have that telephone conversation. So there are certain people, like the people through Manatee Children's Services, that I was going to be speaking to, for example, Kimberly Griffin, who is the case coordinator. But in addition to that, I asked both Ashley and Doug for their own people that they'd want me to speak to. But then, of course, doing the evaluation, I have the kind of wherewithal based upon what I learned from them, if there are other people I need to speak to or that I believe I should speak to in order to get a more complete picture of the individual.
Okay. And did you, in fact, do that with reference to both of them? Speak
Yes,
to collateral contact?
Yes, I did. Yes.
Okay. Did you meet with Doug and Ashley and Emerson together or separate?
Given the structure of their family unit, I had multiple interviews with each of them individually. I had several interviews with them together, a couple of interviews with them together as the couple, but several additional interviews with them when they would exchange Emerson at my office, and when we would, kind of see how that the drop off or the exchange goes.
But I had also seen each parent with the child, both in their residence as well as in my office. So there were multiple interviews.
Okay, so this sounds pretty extensive. So how much time did it go on over?
Throughout the summer of 2020, I think the report was actually completed and submitted on September 14th of 2020.
So I want to speak with you about Ashley specifically. Did she ever show any hesitation about meeting you with Doug present?
No.
Did she act differently when she was with Doug meeting you, as opposed to when she was not with Doug meeting with you?
As I had indicated or described in my report, she did demonstrate or present with a different demeanor when seen together versus when I would just see her individually.
Okay. And when you saw the two of them together, did they discuss the plans for going forward? And I'm talking about moving. So did they discuss that with you?
Ashley had made it very clear that she had every intention and desire to relocate back to her home state of Maryland. Doug had the impression that this was something that he too could do because he had some connections through the Defense Department and some of the work that he did. He felt he'd have more clients up there, so he was perceiving that as he shared with me, a fresh start that they could reconcile and be together in Maryland.
And when Ashley and Doug met with you together, did Ashley indicate that this was the plan, that they were moving all together as a group?
Ashley had no intention of moving together as a group. She had every intention of moving with her mother and Emerson and becoming situated in her grandmother had passed away and the mother had inherited the house. So they had their residence established. So she had that plan.
Okay. And so I guess I wasn't being very clear. Were they moving their items together, like same U-Haul truck?
No, absolutely not.
Okay. So Ashley never told you about that?
Quite to the contrary, she made it clear that she did not want him to move in, regardless of what he thought or whatever he was planning. That was not part of the plan.
Okay. And when she was alone, she would indicate to you those things that you just described? Or
Yes,
did she indicate that when she was with Doug?
When she was with me during our individual meetings.
Okay. When she was with Doug, how was her demeanor? How was her attitude about those issues?
She would basically respond in a very deferential way. She would let him say what he wanted to say, but my focus was not so much on what their future plans were. It was they weren't even officially divorced. My focus was, again, getting back to the point about the best interest of the child. Child protection team is, how do we get this family out of this stressful situation and then create something that's going to be better for Emerson.
Did Doug, during your joint sessions, did Doug express in front of Ashley that his hopes that moving forward, this was going to be an attempt at reconciliation? Did he express that in front of Ashley?
Yes, he did.
Okay. Did Ashley ever correct him and say, whoa, wait a minute. No, we're not doing that.
Not really. I think the closest she ever got to that was to kind of say, well, just kind of slow it down and, we'll talk about that later. And that's, that kind of thing. She would kind of deflect attention away from that.
And did she ever say in one of her individual sessions with you, did she ever say anything to you about she was running out of time and needed to move to Maryland or something like that? Do you recall?
Yes, we had that discussion in one of the sessions.
And can you just explain what she said about that?
In essence, she was very frustrated and concerned that
As I understand it, he's called as a fact witness, and he's giving opinion.
I'm sorry. Jules does not look happy.
Okay, you can answer the question. What was it that she said about the issue of running out of time and wanting to move to Maryland?
She was openly sharing with me her utter frustration with the sheriff's office, with CPT, with the court system, indirectly with myself, although she had also complimented me by thanking me for doing a quote unquote thorough job. But who was going to look out for Emerson? Who was going to help Emerson? And she needed to do something. She needed this to be over with so she could get on with her life. She used the phrase, "My life is in a shambles."
Okay. And did she make any statements to you about why she needed this to be over so quickly? Or why was it, did she feel it was taking too long? I guess should be my question.
She certainly felt it took too long and she just wanted to get on with her life.
Okay. Did she admit to you that she was in fact going to marriage counseling with Doug?
She had been in agreement with them starting with a second marriage counselor, Dr. Quintel, after their attempts at marriage counseling with Sharon Foster had not worked out.
Okay. So she indicated that their intent to go to Dr. Quintel. But during the same time, was she still saying they would not reconcile, or she was saying they did want to reconcile?
I don't think she ever used the word reconcile when with Doug. She clearly made it very clear to me that she had no intention of reconciling.
Okay. And during this time, I would say the year at least before your meeting, did Ashley talk to you about doing things with Doug? And for instance, I'm talking about lunch and activities. Did she talk to you about that?
Throughout the time that I worked with them, it was very clear they were very open, sharing with me the things that they would do together, such as, for example, the hit movie that particular summer was the sci-fi thriller Tenet, T-E-N-E-T, and they had agreed to go see that so the grandma could watch Emerson. They have a quote unquote date. They enjoyed the movie so much, but also found it kind of confusing, hard to follow, that they agreed to see it a second time together and had a follow-up date for that movie. But in addition to that, they had done other things. She would go to Doug's apartment complex where they could use the community pool and take Emerson into the pool. They shared with me that they had gone to the beach. She described in detail watching Doug. I think it was Father's Day specifically in my notes there, where she described how nice it was to see Doug playing with Emerson, playing in the sand with Emerson. And so then from there, they would go out to lunch or go out to dinner, sometimes with Emerson and the grandmother, sometimes without. So they were, throughout the time I was working with them, they were seeing each other.
Okay. Did Ashley ever talk to you about the birth certificate for Emerson?
Naturally, in this kind of evaluation, since it concerns a child, they talk about the child and the marriage and the relationship and see each parent with the child. So yeah, that came up. She gave birth at Tampa General Hospital and signed the birth certificate. Emerson Grace Caney.
And do you know whose name Caney is?
She wanted to keep her grandfather's family name, and so therefore she used that name.
Okay, so the child wasn't named Benefield.
Was not.
And did she ever put, or did she indicate to you whether she ever put Doug on the birth certificate as the father?
She did not. That became a point of contention with the two of them, things that they were discussing, changing the name from Emerson Grace Caney to Emerson Caney Benefield. That was an issue that they were discussing.
And did she ever admit to you that she didn't tell Doug that she was even giving birth?
She shared that she did not inform him.
Okay.
Thanks for coming, Sneaky Side.
And you mentioned a little while ago that she was frustrated with some of the agencies. I think you said law enforcement, the courts, that kind of a thing. Did she express why she was upset with them?
She felt that Doug was unfit to parent Emerson, that he was only using the child to get her back, to win her back, so to speak.
And these agencies, they played into that or they didn't play into that?
What was described and came out of our discussions in the interview sessions was that she felt that no one was willing to step forward to protect Emerson, that they all got it wrong, for example. So when CPT evaluated the situation where she had bruising on the neck, she described to me that it was several days later, so the bruising didn't show up, and that went down as unsubstantiated, so it was never followed up on. And
Okay, so she basically felt like they were getting it wrong. These agencies were getting it wrong.
no one was protecting Emerson. She did not agree with that.
During one of your last meetings with Ashley, did you have a conversation with her in your waiting room?
The day after, a day or two after the report was submitted on the 14th, Ashley showed up in my waiting room, unexpected, unannounced, and she wanted a copy of the report. And I had explained to her procedurally that the work product that I produce is then the property, in this case, of Manatee Children's Services, and had submitted to them. But I let her know that, you know, she'd be able to get a copy through her attorney, but they did have to get a court order to release it. And that's usually what happens. It's kind of a formality, but it's no longer something for me to share or divulge.
Okay. And did she have a reaction to that?
Her reaction was that she felt, again, very frustrated, thwarted in her efforts. She wanted to get on with her life, and she felt, she needed to know what was going to be recommended so she could move on.
Okay. And during that conversation with her, did she say anything that that struck you as interesting during that conversation with her?
Well, she had explained previously and then repeated it then that once she was able to relocate to Maryland, she wanted to establish residence, as she had, in essence, researched it, knowing that if she had established residence for at least 6 months, she could then appeal to the authorities in Maryland to get relief and have Emerson, basically have full custody of Emerson and not that. So she had used the phrase during that conversation that she would take matters into her own hands.
And did she express to you at that time about being frustrated about the timing, things weren't going fast enough?
By that time, she was, again, ready to move on, and she was frustrated with the entire system.
I wonder if she had another sweet thing.
And did she make any more statements to you at that time?
Just saying.
Not that I recall. Again, I tried to encourage her to be patient, that her attorney would definitely be able to get a copy of the report, and they could, work things out once they read the report, and they should be able to settle things.
Okay. And did she ever say what she would do if it wasn't fast enough?
No, I don't think she specified anything more than her desire to, again, get on with her life.
Okay. When was the last time that you saw Ashley? Was it that day that you're talking about?
When she came to the office unexpectedly, yes, that was the last time. Prior to that, the last time I actually saw them I saw Doug on September 7th. And then I believe I saw them together on the 10th of September.
Okay. And the last time that you saw them together, how did they seem? Did they seem the same as they had the times that you had seen them before?
Well, Doug too is becoming frustrated because he was viewing this as a fresh start, as I said.
Okay, I'll move on. Did you complete the report for Ashley Benefield?
Yes.
And how long was that report?
27 pages.
And did you do the same type of a report for Doug?
Yes.
And was it about the same length?
I think 24 pages.
Okay.
I'm sorry, 25 pages.
Okay.
I don't think they can get into the specifics.
I think you already
I wish they
explained
would.
this, but you turned your report over to CPT when?
September 14th.
September 14th. Okay. And then what happens to it after that is not in your hands.
It is, sometimes I find out, sometimes I get feedback, sometimes I don't. It's the work product goes to, in this case, Manatee Children's Services, and
And did any of your evaluation or contacts give you any concern for the safety of Ashley or her child going forward?
their original marriage therapist, Sharon Forrest, had concerns. She certainly expressed concerns, yes.
Did you have any concerns? Well, let me ask you this. Did Ashley Benefield ever say to you that Doug physically harmed her?
No.
Did she present you to you as being fearful for her own safety at the time she was having sessions with you?
Her concern was all about the safety of Emerson, not about herself.
Okay. Thank you. No other questions?
Excuse me.
Cross.
Give me just a moment, Your Honor.
Give me, baby girl. Good girl. Here you go. I want a snack, y'all. I'm getting hangry. Nope, they're not going to have access to the actual report. But I'm believing this dude. If there was really just cause for belief that there was physical abuse between him and her, they would have documented and they would have done something because it affects the child.
Good afternoon, sir.
We've met before.
Yes, sir.
Your history in this case has wound its way through to where we are today. And it's
Really?
encompassed prior proceedings, has it not?
Yes. Yes.
Okay. And you've had occasion to sit for a deposition in this case,
Yes, correct.
and you've also given previous testimony.
Twice before in the
All right.
dependency
Don't
case.
tell me where.
Okay.
So you've told us that Ashley would act one way when she was with you, but she would act differently when she was with Doug. Correct?
Yes, that's correct.
All right. And your conclusion that you reached was that she would appease Doug. Was that not the case?
Ashley had shared with me a number of times that she felt the best way to keep Doug at bay so he wouldn't hurt Emerson was to kind of appease him, to kind of go along with him.
Yes. In your words, I believe in your report, go along, get along.
I believe that's correct.
Correct?
Yes.
And that would be especially the case when Emerson was involved.
Yes.
All right. So for example, if she didn't particularly want to be in the
Oh my gosh, y'all. This is, I think we're about 123, 24 objections. Y'all, what do you think? Oh my gosh. Well, for me, if I'm on the jury, right about now, I'm seeing more reason for just cause, meaning she did do it, than I am reasonable doubt. I don't foresee any reasonable doubt. Now that's something that you guys may disagree with me, but the more it goes on and more I see, and I'm, what in the world? Oh, I had a sticker, sorry. Definitely, I believe she's more guilty. I really do. So I'm I'm not sure what to think. What concerns me is her high level of manipulation. First, with the police officer wanting her husband arrested in front of a judge, and then she's trying to manipulate to get reports. And she just seems like a very high level manipulator. And if she's done it to this man, how many other men has she done this to? You don't just develop this character overnight. You keep, this is a pattern of behavior, in my humble opinion. But I feel this case just makes me sad. Poor Emerson. And did she just use him to give birth to a baby? I mean, she didn't have to go through all this to get a baby. I'm not trying to be tacky or mean, but she could have, she could have gotten a baby other ways. She didn't have to go through all of this to get him. Yeah, these sidebars are irritating me beyond reasonable belief. Beyond belief. I'm trying to get my hair to do that little fat, but I may have to reposition I've never done this to my hair before. I'm trying to make it look all cute. But y'all, I don't like the way that music sounds. I need to get some loving to our sponsor, y'all. So let me do that real quick. We love my sponsor. She keeps me going, and I'm going to get me some water so I can get me some more. Hey, y'all. I am so excited we have our very first sponsor, and I'm wearing this hat to honor them. Who is it? Well, it's coffee, my favorite thing. This coffee is from Hitchman Homestead Coffee. This is the Shooter Shack Coffee Pioneer Nicaraguan Roast. This coffee is so delicious, y'all. It is so smooth. It does not leave a chemical taste on the back of the tongue. It's not overly bitter. And I have to tell you, it is my favorite. And I am now getting rid of all my other coffee. I kid you not. They have a monthly subscription available. You get 4 12-ounce bag a month, either whole beaned or ground. And then you can also get a Keurig option as well. The other thing they have is wonderful gift boxes that you can send to your loved ones. So you want to support a fabulous home business and people here in the Hill Country, go to hitchmanhomestead.com and let them know I sent you, and grab yourself some of the best tasting coffee we have here in Texas Hill Country. Oh, get my coffee brewed. Can you hear it? And got my candles lit for some zone. I'm kind of getting a headache, so I'm going to cut back on the lights. Oh, that feels so much better. Y'all, it is hard sitting with the light just blaring at you all day. We're late afternoon. We're getting the mood going. I know. I do want to see the defense say in their case in chief. I didn't know quite what we were getting into when we did this. Honestly, I really didn't. I really didn't know much about this case. This is how I enter all of my cases. And unfortunately, so many other people are showing this case. But once again, I'm still going through a growing learning process. So I'm happy to be doing this. But this case just seems uncomfortably weird to me. I mean, with all the other cases, I felt a little more clear-minded. This case, I am just now at the end of day 2, finally getting like I fully understand the dynamics of this case. I really appreciated the way the prosecution statement was. It laid a good timeline, but the defense just seems unbalanced. I don't know how to put it. I just have no words for how I feel. That'd be good. It's about that time of day.
So I think you told us, Dr. Broder, that this policy of appeasement was designed by Miss Benefield to basically placate Doug Benefield.
I think I would use the word strategy. That was her idea of trying to.
Yes, to placate him. In other words, to not set him off.
She knew that she wanted to reconcile, so she wanted to kind of, I think, feed into that so he wouldn't, given her belief that he might hurt Emerson.
Okay. And you, did you decide whether or not the signs were there, but that Doug Benefield refused to recognize them? That she wanted no part of a marriage to him?
Let me make sure I understand the question. Are you saying, did I discuss with him about the signs?
No. Did you acknowledge during the course of these evaluations that the signs were there that Ms. Benefield did not want to be in this relationship with Doug Benefield, but he misinterpreted them and insisted on trying to be with her?
Unlike therapy and evaluation, you're constantly generating hypotheses, meaning asking other questions to make an assessment of the overall situation, different than a therapeutic relationship where you might be making interpretive statements and recommendations.
That's
Let
not
me
the
ask you
answer he
this.
wanted.
Did you consider that Ashley's position was that Doug was only interested in her and not in the child?
I certainly considered that, yes.
And that was Miss Benefield's position, was it not?
That his sole aim was to win her back, yes.
The abuse complaints, without giving me names, they were initiated by more than the same person, correct?
Correct.
In fact, there was.
Objection.
Finish your question.
In fact, there was at least 3 different sources.
I'll overrule. Go ahead.
I believe there were 3, correct.
And 2 of those sources were professionals.
Sustain.
You cannot be forced to tell who the people were, professional or not.
She expressed to you, did she not, real frustration with the system and its responsiveness to her situation?
Yes, she did. She was very forthright.
And she told you that with respect to taking matters into her own hands, it was going to be by virtue of her going to Maryland and petitioning the authorities there.
My concern was that she was going to impulsively abscond with the child and go to Maryland and, yes, establish residence separate and apart from Doug.
Okay, that she would have access to the authorities there, that they might be more responsive.
That was her hope, her goal, yes.
All right.
Miss Kevin, second shift doesn't start for another 6 minutes for me. I kind of like my ponytail like
Are you
this.
familiar in your practice with domestic violence?
Yes.
Have you treated it before?
Please.
Assessed it and treated it on occasion, yes.
Did Douglas Benefield from what you learned as a result of your involvement in this case, exhibit
Couldn't finish your question.
symptoms consistent with the domestic violence abuser.
Sustained.
Give me a
Oh,
minute,
thank you,
Your
Miss
Honor.
Kevin. I've never done my braid this way. I've always had it typical flat native, not styly. Like up there. Kind of like it. Wish I could get that up like that. It is.
I do have one other area of inquiry, if the court will allow me.
Do they have a choice? Ooh, I wonder where Miss Jules went.
Did you find anything aggressive about Ashley Benefield?
No,
Did you find that Ashley Benefield had any impulse or was prone to angry outbursts?
well, that's two different things, impulsivity and angry outbursts. I did not find her to be having angry outbursts, no.
You in fact concluded she was a good mother.
Yes, I observed her many times.
That's all. We'd like to keep Dr. Broder under subpoena.
Redirect.
You're familiar with mandatory reporting laws, right?
Yes, ma'am.
And what does that mean, mandatory reporter?
The mere suspicion of any kind of abuse towards a child or an elder, as well as domestic violence, needs to be reported.
So if someone goes to their child's pediatrician, or someone comes to you as a doctor and alleges abuse, what would you have to do?
I would have to report it.
Thank you. No
If
further-
she alleged it to a physician
Doctor,
or
at this point,
professional,
we're done asking questions. However, as you've heard, you remain under subpoena. The rule of sequestration.
okay, I'm going to say something here. First of all, that's true. So if there were two professionals that reported it, it's probably because she reported it to them and they have to, by law, report it. I've been there many times. One thing that they said was that they don't see any aggression in her. You guys, I know women who can be as calm as this woman here is in the middle of a crap show. And then when they're out of public eye and they're in the comfort of their home with their spouse and their family, they go ape nuts. I won't go any further how I know it, but I know it. And it's like two different people. Not multiple personality disorder, but there were two different people. They had this mask for the public, and then they had this one over here. You can never assume just because she's never showed signs of aggression in front of you that she's not capable of this crime.
Has been invoked in this case by the parties. So that means
My
you
humble
cannot
opinion.
discuss your testimony or the questions asked of
My
you
life
with anyone
experience.
else, including the attorneys.
Okay.
You can't talk with any other witnesses about what their testimony was or the questions asked of them. To the extent there may be anything online about this case.
We maybe have time for one more.
All right, so remain available in case you need to be recalled.
Just point of clarification, remain here today or be ready for tomorrow
No,
or
sir.
what?
No, sir. You're released for now. Just if one of the parties reaches back out to you during this trial period, you will need to report back.
Understood. Very good. Thank you.
Okay, guys, I can make one of the announcements right now. You guys, we have a new member of our team. We have a mod, and that is, are you ready? Are you ready? Are you ready? Drum roll. Did y'all hear it? All right. The person is Miss Sneaky Side. Welcome to the team. We love you. We appreciate you. We look forward to having you a part of our team. And you have been a great, great viewer and participant. And we are blessed to have you as a part of the team. So thank you so much. I know she had to run. We'll announce her again this evening. But I still have another announcement to make. I'm going to keep my mod boss on the edge of her seat, too.
All right, State, call your next witness.
State calls Dr. Jason Quintel.
This is all they had for witnesses, and most of them aren't even on the list. Come on, mouse work.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth. Yes, ma'am.
Thank you.
Hello, sir.
Hi there.
My name is Judge White. I'm presiding over this case. As the deputy may have said, just make yourself comfortable in that chair.
Okay.
You're going to end up wanting to be about 12 to 15 inches from the microphone. It adjusts up, down, left, right as you need.
Okay.
If you just speak in a loud, clear voice right into that microphone, it'll pick up everything.
Okay, great. Thank you.
Good afternoon.
Hi. Sorry, I spilled water.
Please state your name.
Dr. Jason Quintel.
How do you spell your last name?
It's Quintal.
What is your profession?
I am a mental health counselor
How long have you been a mental health counselor?
since 1998.
And where's your office?
My office is in Lakewood Ranch, off of State Road 70.
And how long have you been there?
That location we moved into in 2018. Prior to that, we were on Lena Road from 2008 on, and then prior to that, 2006.
And at some point, did you become familiar with Doug and Ashley Benefield?
Yes,
And when was this?
that would have been in 2020.
And do you recall about when in 2020 that was?
They came in for their first visit as a couple's visit on 7/15/2020.
Okay. So we heard from Dr. Broder, he was talking about his goal was to do an evaluation. What was your goal with meeting with them? Was it an evaluation or something else?
No, I was referred by another therapist to do trauma resolution treatment for both Doug and Ashley.
Okay. And as part of that, did you meet with them together as well as separate, or how did that work?
I did. I met with them originally as a couple. We ended the treatment as a couple, and then there were individual sessions in between.
Okay. I won't hold you to this, but about how many times did you see them?
So I met with Doug twice individually, Ashley 5 times individually, both of them as a couple twice. There was a total of 4 hours for couples, 10.5 hours for Ashley, and 4.5 hours for Doug.
Okay. And at the first session, did it seem to you as though, let me back up. The first session, was it together?
Yes, it was.
Okay. And during that first session, did it seem as though they wanted to work things out?
No.
During the first session, they talked about, yes, they wanted.
I like gray hair.
When they were together, did they indicate they wanted to get back together? like reunify?
The goal was for them to reunify and moving to Maryland.
Okay. When Ashley met with you by herself, did she still make that representation?
That they were moving to Maryland, yes.
Okay. And was there anything different about her representation?
Ashley was different when she was separate from Doug in terms of more descriptive of things that had happened between the two of them that troubled her. So some stuff that was scary.
And we won't get into
Sure.
specifics, but
Ask the question. He's entitled to complete his answer.
so did she indicate she still wanted to reconcile with him when she was?
Miss Haley, do you know why he's so excited? Dang it, these hearing aids. Do you know why he's so excited? He's working up a good one.
With you alone. Did she say she wanted to reconcile with him when she was alone with you?
So I don't recall whether she said she wanted to reconcile with him or not. I think that there were challenges in their marriage and she was questioning whether she wanted to be with him or not.
Okay. Did Ashley tell you that she and Doug were also seeing Dr. Broder?
They both mentioned that Dr. Broder was doing an evaluation, and I didn't know what it was regarding.
Okay. And did Ashley say to you at any time that she was frustrated with the system?
I think Ashley was discouraged. There had been many things brought up, accusations, CPS, judge, that didn't go her way. So I think there was definitely some discouragement with that.
Okay.
She.
And I'm sorry to cut you off.
No, you're fine.
Did she express any frustration at the time it was taking for Dr. Broder's report?
Yes, she thought that that was taking a very long time.
Okay. And did she express to you that she was worried about what his report would say or worried about when the report was released?
She was worried about what it would say. She said if it were to be disparaging of Doug, she was concerned that he would be upset and take some form of retribution with that.
Okay. Did she, the last time that you saw them was when?
The last visit was on 9/25/20.
Do you remember what day of the week that was? You might not, but.
Maybe Thursday, Friday. I can look if you need that.
No, that's okay.
Okay.
And about what time of day was it?
I believe that was a morning session, 10:30-ish.
Did they say Dr. Broder's report was done?
I don't recall them saying. No, I don't. There was not a when the report was going to be released. It was going to happen at some point.
Okay.
My understanding is that they still had plans to move to Maryland.
Okay. Thank you. I have no further questions.
Okay.
Cross.
Afternoon, Dr. Quintel.
Hi.
How are you?
I'm doing fine. How are you?
Good. So tell us why, when you met with them, Ashley was different when she was alone and when she was together with Doug in meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no,
Objection, Judge.
Sustained.
Not gonna get into specifics.
Okay, without. Yeah, oh, you have no idea. Without,
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out?
Oh,
Remember, please don't begin your deliberations. You can't use your phone. Don't talk with anybody outside of the jury.
oh.
And don't do any research on the people, places, things, or legal topics you've heard anything about.
Somebody's in trouble. Trouble.
You to the hallway.
okay, take
The-
my stuff with me.
Yes, sir. The rule of sequestration has been invoked.
I don't even know what that means.
Okay, y'all
sorry.
missing it. Y'all missing it.
What that means, you can all have a seat. What that means, sir, is that you're not to discuss your testimony or the questions that have been asked of you here in the courtroom.
Oh my gosh, y'all.
It also
Somebody's
means that
going to
you
get in
can't
trouble.
discuss, other witnesses' testimony, and that's with anybody or the questions they were asked. That's with the attorneys, other parties, witnesses. It doesn't matter. You can't discuss anything that's gone on inside the courtroom when you've been in here. Also, that I understand this may be online, and you are not to watch anything online until you're released from your subpoena or the jury has been released from its duties.
Okay,
All right, so if you
sounds
can step
great.
out. Thank you.
Thank you.
Oh, something's going to happen. Well, it's 4:15, but that lawyer should have never said that. I hope this doesn't cause a mistrial. Oh, what if this causes mistrial?
Mr. Taylor, is there anything you'd like to share before I begin speaking?
I think I'm about to catch a whooping.
Yeah.
I'm not quite sure why, but go ahead.
I believe that you expressed you're a veteran of over 400 jury trials.
Yes, sir.
This is all rhetorical. You can feel free to answer or not answer. My assumption is that you're familiar with trial process and procedure, that you're familiar with, as you had mentioned earlier, the rules of professional conduct and decorum. I'm also sure that you realize that if this court makes rulings that you disagree with, whether it's a passing disagreement or a fundamental disagreement with a ruling, I would imagine you're aware of the fact that if ultimately your client is convicted, either you or another attorney or a public defender, if she's indigent, will have every right to appeal to the Second District Court of Appeal every decision I've made from the minute I sat down in this division and started making decisions in this case, all the way through the end of the case. I also would imagine that I'm not the first judge that has made rulings that you disagree with. I would imagine I'm not the first judge that you have looked at up here and said, where in the world did he or she get that from? I would hope that you have not engaged in the conduct like you just did. It was inappropriate. It was unprofessional.
Is he going to
We're going to take just a few minutes break.
contempt of court?
I have this position and I understand criticism. And I expect that. I have often said that I think my job early on as a youth sports referee and umpire prepared me well
Ooh,
for
that's
the
good.
criticism that comes with the job.
Mm-hmm.
However, those sorts of side comments are just, they're not appropriate. And I would caution you, sir, not to do that again. That's extrajudicial matters that have nothing to do with the case or the consideration of the jury. All right. So we'll take a 5-minute break and we'll be back.
He's I hope Jules was in there for that. I don't see her. Where's Jules? I know she's still getting over COVID, but where is she? I was hoping she'd be in there for that one. Holy crap. That was priceless. Oh my God. Miss Kevin. Oh my God. That was OMG. Oh, that was just all kind of wrong. That was all kind of wrong. Oh, Mr. RA is laughing his butt off. He knew exactly what he did. I love this judge. This day turned out to be better than I thought it would. Oh my gosh. I will tell you that this judge is rocking it. I agree. The thing about this judge is he has been so level-headed. I'll wind it back. I'll wind it back. Here we go.
There had been many things brought up, accusations, CPS, judge that didn't go her way. So I think there was definitely some discouragement with that.
Okay.
She.
And I'm sorry to cut you off.
No, you're fine.
Did she express any frustration at the time it was expressed? And
Going to be
Or not to
without Doug, there was prior acts
Here
of
it is.
violence, shooting a gun, no
sustain.
Okay, without. Yeah. Oh, you have no idea. Without.
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out?
Oh, he's like, oh shoot. I just stepped in
Please
it.
don't begin your deliberations. You can't use your phones, but don't talk with
He
anybody
knows.
outside of the
He
jury.
knows. He knows. Oh my God, y'all. That was so funny. Yeah, that was good. Oh my gosh, y'all. That was hysterical. But I like this judge. He has been fair, even. He's calm, even in the midst of this. It's because some judges. I apologize. I'm having an issue with hearing myself, and I'm catching my pronunciation being off, and I apologize. It's a deaf thing. So, the judge has kept himself calm, where a lot of judges would have blown. I don't see anything wrong with what he said. Okay, here's the thing. When you have a jury sitting there and there's an objection and it's sustained and the witness kind of went, oops, like, did I say something I shouldn't have? And he kind of looks at the the defense attorney, and he took a deep breath and he goes, you have no idea. In front of the jury, that is showing disdainment for all the objections, and he's showing and voicing his lack of happiness with the way the court is handling the trial. That is something you don't do because that can influence a trial. In fact, it can cause a mistrial, depending on how bad it is. So it's a matter of professionalism, code of ethics, and things like those little things really can affect a jury. It can affect how the jury kind of, what's the word I'm looking for? It can influence the jurors in a way that they normally would not have been. So some lawyers can be getting in trouble with a judge, but the evidence really doesn't show that their client is guilty. They can take that behavior and kind of form a opinion. Otherwise, I'm not doing good at explaining it. Well, he
All
ruled
right, let's
on
round up Dr.
the actual thing. Yeah,
Quintel.
he could not.
Get him back in here.
He can say yes or no, but he can't sit there and throw the examples. He wouldn't ask. He only asked if there was a small hole. He didn't ask and couldn't if it was a gunshot. First of all, the guy's deceased. He can't defend himself. There's a fist in the wall, a hole the size of a fist, but he couldn't say anything else. But it was just bad decorum, unprofessional, and rude.
Of the prior court orders and admonish them to stay within those bounds. All right, go ahead and bring in Dr. Quintel.
That was like wrong. Now, where is Jules? I hope she's okay. I know she hadn't been feeling great. She didn't look like she was feeling all that good. My assumption. And you know what assumptions do.
While you were outside,
That's a baby
did
girl.
anybody attempt to discuss the case with you or speak with you? Or did you speak
You're
with
welcome.
anyone at all about your testimony or the issues we talked about?
I did not speak with anyone. There was a reporter that came up to me, but I didn't engage with him or interact with him.
All right. Did that person ask you questions?
He said that he knew I couldn't talk, but here's a card. I said, I don't want that.
Okay. All right. Anybody
Good
want to
for
follow
you.
up questions about that? All right. Everybody says no. Let's bring in the jury.
Good for you. Are you okay, Jules? We don't see you. Kitty, 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 kitty. Witness, stand up.
All right, you all can have a seat. Welcome back, everybody. Anybody begin deliberations, talk or communicate with anyone outside the jury about anything we've talked about, or do any research? Everybody says no. All right, Mr. Taylor, you may resume your cross-examination.
Thank you. Doctor, did you, as a result of meeting with the two of them together and separately, did you reach any conclusions about the relationship?
Objection, relevance.
This guy is
All right, you can
scared.
approach.
Okay, I got to back away from the mic. I'm excited. This guy is scared. Dang it, I didn't see Miss Jules. I'm worried. I do care about her. Sleazy move. Hey, it's voicing his frustration in front of a jury, and you can't do that. Big no. Real quick. Oh my God, y'all. We did it. I can't believe it. We actually did it. Exciting news. Memberships have launched. Memberships are a great way to financially support this channel. Starting at the juror level of membership, we will be hosting members-only lives. Also, at the judge level, we will be having VIP events. We hope you will enjoy sporting the membership badges and soon to come exclusive emojis. Thank you for watching and supporting the stream and my dream to provide accessibility to the deaf and hard of hearing. Okay, they still up there. She could be, but that's a long time. So I'm sorry, I was typing. And the fact that the judge was calm, he addressed it. He took 5 minutes to take a breath. Now he has to come back in like nothing happened. That is a good judge. Very good judge. Yeah. I had a hole in the ceiling of an apartment once. My friend was, I played pool and she was twirling my stick and she went up, poked a hole in the ceiling, same size as a pew pew, a lead. Same size, almost. You can't assume. You can, but makes a you know what out of you and me. So it just depends. It really, really does. It depends on the situation and what's happening. Okay, she's still there. She just moved. Oh, thank God. Thank God. Yay. Okay, love. Okay, she just moved. That girl sat right in her eyesight, so she moved. I just want to make sure she's okay because she really had COVID bad. And I'm okay to share that. She told me it was okay and she shared it. This has been an interesting day of trial. Far better than yesterday. At least we had some spice. I'm waiting to get to the medical examiner. That's what I want to see. Y'all, I got to start beating my native stuff. I'm so far behind. So I may start beating during trials. If you see me doing that, I've got a deadline and I'm way behind. Way, way behind. Yep. Mm-hmm. The implications bother me. If you can't say he put a fist on the wall, then why would you go, is there a hole in the wall? Mm-hmm. About the same size of a fist? Mm-hmm. Well, Miss Kevin, if you were in court and somebody asked you, is there a hole in your wall? Mm-hmm. Yes. Is it about the same size of a fist? Yes. Does that mean your husband lost control and was enraged and put his fist in the wall? Or from a bookshelf when you moved in, you can't distinguish. That to me is what's bothering me about this trial. Is if you can't get the evidence in, if there's a rule, then you shouldn't be able to even allude to it, in my humble opinion. My head's starting to pound. We're all suffering headaches here. That's right. I'm gonna get me some Excedrin. Migraine. I don't need a migraine tonight. He's being very serious. He thought he did something wrong. He didn't.
About why Doug Benefield would want to
Yep.
stay in this relationship.
Overruled.
You can answer.
Can you repeat the question, please?
Yeah.
Thank you.
Was there any observation by you in response to why Doug Benefield would want to remain in this relationship with Ashley Benefield?
I questioned why both would want to stay in the relationship, but specifically to answer the question with Doug, I did bring that up in a session, that it seems like Ashley is saying very disparaging comments, and I'm not sure why and what you see in that ongoingly moving forward. I did bring that up to him.
In fact, you were perplexed by it, were you not?
I was confused, sure. It did, yeah.
Would it be a fair conclusion to say that he was hell-bent on staying with her?
I would say that he really wanted the relationship to work from everything that he told me.
Okay. We're gonna have to recall you, so I'm done.
Redirect? All right, sir. So at this point, you are going to remain under subpoena.
Okay.
You're free to go now, but one of the parties, one or both the parties may actually call you back later. So all those instructions I gave you earlier still apply. Don't discuss your testimony.
I bet they end today.
Even the attorneys, any other witnesses, you can't watch anything that might be online or read any news.
No
Other than that,
interest in anything of that anyway.
You're free to go now.
Just because you may have a temper doesn't mean you're abusive. And I know a lot of people have a hard time with that comment, but it is true. He probably was a really good guy and lost his cool because of the frustrations that she was putting him through. He never hit her. We have no evidence that he hit her, just like Donnie Depp and Amber Heard.
Thank you, sir.
Have a good rest of your afternoon.
You too, sir.
Thank you.
Well, there could be if it's short. I feel weird. I don't have my blush on. It got spicy today.
Okay.
Approach. Really? I think we're done for the day. We are at 131 objections. In 2 days.
All right, members of the jury, the next witness may take quite a while. So instead of keeping you so late tonight, the attorneys and I have agreed it's probably better to just come back tomorrow morning and start fresh. So I'm going to let you go for now. If you would please, same tomorrow time. Are you guys okay with the time? All right. Let's again plan, what would we say today, 8:45? And get you up here and hopefully get started right about 9. So let's do the same thing tonight. Please remember, no discussion amongst yourselves. Talk about the weather, nothing else. Don't talk about the case with anyone outside of this jury. And don't do any research on people, places, things, or legal topics that you heard anything about.
Yes, sir.
Okay? See you tomorrow morning.
Okay, we're done. Oh my gosh, we had some crazy moments today. We really, really did.
All right, thank you all. We'll see you tomorrow morning.
Okay, so 9, so that's 8 my time. So that means I have to get up at 6:30.
When you unsealed, we got the copies of I got the original order that you did, and then the clerk provided me the transcript and the emails. I think you said something when you said transcript, was that the transcript you referred to? Because the court reporter hasn't transcribed what happened.
Correct. I sealed, if you look at my order, I sealed her raw data, her notes, and any transcripts.
Hold on.
Okay, so I was gonna ask her to do it, but I wanted to clarify before I did something wrong.
I have not requested it. I don't even know if one has been done, but it has been unsealed if there's one.
Thank you, sir.
Does your order, Your Honor, allow the clerk to give them a copy?
Yes. Everything's been unsealed.
I really felt bad for that witness. I really did. He was like, a lot of objections, a lot of snark. I think the first detective, everybody started taking notes and paying attention to him. I agree. I think that he really made a shift and change in the testimony and in the whole environment of how this court is being conducted. We will be coming on later at 6:30 my time, 7:30 East, 5:30 West. And we will be having Miss Jules, Lord willing, come on and share with us about what happened in the courtroom. We will also talk a whole lot more about what happened in the courtroom in general, but we have been on for 8 hours almost today. So I'm going to take a little break, get rid of my headache. We will be back on. Once again, you guys are so awesome. I greatly appreciate you. I appreciate your kindness, your support, your involvement, your didn't mean to do that, etc. You are awesome. Once again, please don't forget to comment, like, and subscribe. And I will get back with you at 6:30. So grab dinner, get some rest. And I don't like that. You can see my walls. I can't wait to get that fixed. There we go. And we shall return in a few hours. But 3 hours. That's great. My time. All right, guys. Be blessed. Miigwech. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.